the unknown, down the rabbit hole, where it stops, no one knows. We're going head into the unknown. Na, 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 na.
Hello, hello, hello. Happy Thursday. Today's Thursday. Yes, happy Thursday, everybody. Good to see you all. Hi, Carol freaking Claus. I feel like it's been forever. So good to see you. What's up, Terry? Let's go. I'm missing unsolved crime. What's up, Tracy? Hey, Julie. Thank you for always asking about my mom. She's doing okay. She's working on it. She's on like an intense physical therapy, so I appreciate it. Hey, this response is just, it's cute. That's what it is. Hi, Carla. Hi, Jax. Hey, Sam. Hi, Dom. I hope you're doing okay. Hi, Candace. BG. What's up, BG? Inspector Gadget. Hi, Starlight Ann. Hi, Kelt. What's up, Sherry? Rexy. Hey, Lorna. Danielle. Ditch Comfort. I like my comfort. Do I have to ditch it? Python Chick. Hey, Shaz. Tony. Ginger Snaps. Yeah, you did. Yeah, you did. Hey. What's up, Dina? J-Yo. Nonstop Mom. Hey, Deb. Spicy Cappy. I think I got most of you guys from up there. I'll go back down here. Say hi to everybody who's popping in now. Quinny! Hey, Lilith. Peppermint Tea. What's up, Yaya Kelly? Freeze dry it. Hi, ASMR. Tingle Pink. Hello from Thailand. What's up, Christine? Hi, Dustin. You're going to do it live next Wednesday instead of Friday? Okay. 104.5, that's FM. And I know you have an AM station. I saw you talking about in another live. Hi, Crime Curious. ATS. Mace Mama. Macadamia Mama. Maced Mama or Maced Mama? Maced Mama. Maced. Because I feel like you're just going to go around and mace some mofos. What's up, Mendy? Hey, Chair. People probably think I'm very weird for saying hi to a chair. What's up, Chair? Annie, thank you for joining. Holy filings. Yeah, it's just so much. What's up, Queen? Kalida Hope. You're official now. It's witchy and fantastic. I love it. It has all the things that I like compact. So I wish I had a freeze dryer. There's so much. There's so many filings. I haven't even read the last one. We're going to read it together, so I hope it's not like uber boring. It's going to be important information regardless, but it's like 20 pages. And I was like, shoot, I don't have time to read that. I was picking up kids, and then I had to get back here and get ready for you guys. So here we are. Wild Light Arts. I love that name, though. Mace Longe. Moss. Shoot, you're making me go back to English class? I'm screwed. You like the bookshelf. That's like malicious intent. She's like, I just want your bookshelf. I got a new book. You guys know that I followed Murdoch pretty closely. So Mandy Matney, her book just came out. I got a new book. But I'm in the middle of reading the Down the Hill book by Susan Hendricks. Of course I am, right? Like, that's, yeah, this one. Have you guys read this yet? She's like, long story, I can make my own YouTube. Yeah, and then I also got While Idaho Slept. I have not touched this one yet, though. That's my new ones to my collection. We just watched Michelle After Dark. It's good stuff, and Judge G thinks we're all stupid. Yeah, I agree with that. I love the title. Yeah, she thinks the Judge Gull thinks we're gullible. Hi, Johnny. All right, you want to get into it? Let's get into it. Hello, 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 hello. I know it's been a few days. It's pretty good so far. It's and I don't want to go too far into it because you get all kinds of weird things when you like start talking about a book too much. But she hung out with the families, so it's a very interesting perspective going through it. But it's not too bad. I didn't buy Becky Hill's book from Murdoch. Should I buy that one? I heard it was really bad. Yeah, Amazon. Mm-hmm. Yeah, I hated writing papers, and I don't think I could. Yeah, I haven't cracked it open yet at all. I just got that one. So I got to finish what I'm actually doing. Mary! You're not helping your cause here. I'm still so confused. Coffin Dapper soaks. Okay, so since I haven't been live in a couple of days, I missed one of the five. I didn't miss it because I had it, but I didn't get to go over it. So we're going to go over that one first. Ooh, you know what actually I want to do first? I want to do this first. Oh, Starlight Ann, that's so nice of you. Thank you. I hope you feel that way about the other cases I cover. Let's do this. I finally figured out how to get you guys the link to that. It should go in there now. To this. I figured it out, you guys. It took me a little while, but I got it. To this. I've shown you guys this a couple times. I've added some stuff to it. And it's still a work in progress, but that is the link. You guys should be able to navigate around it on your own just by clicking through, and it'll take you to the different sections. I added photos in there. Like I said, it is a work in progress, so venture in at your own risk because some of the things you might want are not there yet. But yeah, so it's just like you can navigate around it yourself now. But I've shown you guys this. Like I said, not done. So you want to see, here's Abby's photo page. Such a little cutie. Okay. And if you guys have suggestions for that, I am happy to hear them because really it's for me, but it's really for you guys. I'll put it in here again. From the people that I sent it to already, they said it's actually better on a computer. I don't know. I have not looked at it on my phone. I made it on a computer, so maybe that's why. Hey, Stacy Bobacy. What's up, Stacy Bobacy? I feel like I should get a rhythm. There's a rhythm to the night. Hybrid. It is. It's a lot of work, and that's what I said. It's not done. So venture in at your own risk. It's a work in progress. So, but at least you guys have it now. Okay, so that's that. Let me move this out of the way. I am working on it on my free time. If any of you guys want to volunteer to help me, just let me know. I'd be happy to let you help me. Hi, Jordan. You need to have an actual website about what you talk about in the documents. Well, so that is all clickable. So every link in there will have, and it will have the documents, but that's like way later because I know that's going to be later. That's not in the forefront of what we're doing. I just know that. What's up, Heather? Oh gosh, I don't know. I feel like I'm too, like maybe I'm into too much. Maybe I gotta. I'm like, all right, maybe I should read the Murdoch book, right? Get out of Delphi for a hot minute. Thank you, Bonnie. Thank you, Queen. Okay, so on the 14th, the lovely Judge Gull, and I hate being so negative about people, but I just have such a, she just irks me. She just irks me a little bit. So on the 14th, she actually filed, I'll just read it, and I'm sure you guys have probably already seen it, but we're going to read it because it kind of, I think, gives us a little bit. I followed that. I followed that case too. His mom just got arrested, and now I'm like, all right, now we're waiting on Wendy. Hi, blah. Did I miss something? Hold on. What's up, Sugar Magnolia? I feel like I missed something. Maybe I didn't. Okay. And then, all right, so 14th, you guys, like I said, you guys have seen this already, but we're going to go through it because it kind of leads us up to where we're at today. Judge France C. Gull thinks that we're gullible, or she really likes to throw her clerk of the court under the bus. Maybe she'll write a book. Yeah, that would be a good one to write a book. She should write one. All right, so she says the court has recently reviewed the chronological. I guess I should back up even a step. The first writ of mandamus was put in because of the CCS, which is the chronological case summary, where you should be able to access all the documents. So attorneys that are not necessarily Richard Allen's attorneys have gone in and put, hey, you know what, Supreme Court, she's not doing her job correctly. You need to tell her to fix this stuff. And this was the big one. Hi, Sleuthy Goosey. That was the big one. So it was like, have her fix this. We can't access the documents. It's bullshit. She should have everything accessible to us. So she had to respond by today. So that's a document we're going to get to. But what she does before she submits her response today is she does this and essentially just tries to throw her clerk under the bus, in my opinion. I bet that clerk's just got to be irritated, but that's neither here nor there. So the court, which is her, the court has recently reviewed the chronological case summary, CCS, in this cause and notes the clerk of the court has not yet made available to the public on the CCS the 118 documents previously made remotely accessible by court order of June 28th, 2023. The clerk of the court didn't do it because, she didn't do it. She was told she was supposed to, and she didn't because we mandated it, back in June. The court previously created a website. No, they didn't. They did not create a website. They created a Google Drive, which I can show you what a disaster it is if you guys have never looked at it. Let's see if I can just pull it up real quick. This was all actually a zip file. So, but this is what it looks like. They essentially just threw all this in there and just said, "Here you go, people, have fun." But it was all zipped, so you had to go and zip all of them, and then you get it. But anyway, I digress. She made it all public for us. Yeah, Google Drive is a hot mess. But she ruled that it was all public, but she did not put it on a website. They did not create a website for it. They put it in a Google Doc and basically said, "Here you go," or Google Drive and said, "Here you go." The court previously created the website for these documents, and the court didn't do any of that. You don't think she was sitting back there making a freaking Google Drive and adding files to it? She didn't do shit about shit. The court previously created a website for these documents as a convenience to the public, and it was not a convenience. And the clerk, and to ensure the public had prompt remote access to these documents. The clerk is ordered to enter these documents onto the CCS forthwith. Now, dagnabbit. The clerk is further ordered to unseal the June 20th, 2023 filing by the Carroll County Sheriff and the July 5th letter from a Department of Correction inmate and place them on the CCS. which we have that too. So we're going to get to that. The court further notes that a motion for Frank's hearing and accompanying documents filed by former attorneys on September 18, 2023, including the Frank's motion, the memorandum in support of the motion, and exhibits list, are marked as confidential on the CCS as counsel failed to supply a redacted version at the time of the filing. Because they didn't redact it. That's going to be important later. So just keep your ear to the ground for that whole thing. They didn't redact it. Including the Frank's memorandum are marked as confidential. Okay, so the court further notes that a motion for Frank's hearing accompanying documents filed by former attorneys on September 18th, including the Frank's motion, memorandum in support of the motion, and the exhibits list, are marked as confidential on the CCS as counsel failed to supply a redacted version at the time of the filing. On October 31st, 2023, the court ordered defendants' new counsel to review the pleadings and discovery and either adopt these pleadings or make their own. If counsel adopts same, they are ordered to file a redacted version of the pleadings. See, they're ordered to file a redacted version, but the old attorneys were not ordered to file a redacted version. So, if defendants' new counsel inform the court they intend to pursue the Frank's motion, the court will schedule a hearing. No, I lost my other page, didn't I? Finally, the clerk is ordered to place and make accessible on the CCS former attorneys' pleadings of October 25th and October 26th. As noted in its prior order, the court considers these pleadings stricken from the record and will not consider those pleadings as the attorneys who filed same are no longer counsel of record. Hi, everybody that just came in. Welcome. Welcome, welcome, welcome. A bunch of low-down fuckery. So, essentially, she's saying, you know what? She had everything unsealed back in June. She doesn't understand what the clerk was doing. It's just, she's just making a mess out of stuff, that damn clerk. So she's now ordered her to put everything on there. Everything that was in this dump of the zip file is ordered to be put onto the CCS forthwith, right now. Do it now. And the two particular items that had to do with the hearing back in the summer, which was about Richard Allen. There was two different parts to it. So there was the part where they wanted Richard Allen moved because, of the treatment there and what he was going through and so on, and they wanted him moved. And then there was also a suppression hearing that was supposed to take place. Well, she bounced the suppression hearing, essentially telling them they had to file a Frank's motion, which is then how we got here where we are now in life. So she orders that stuff to be unsealed or, put back on the CCS because she can't claim that's from the June stuff because that wasn't around in the June stuff. So she has to add that to it. Okay, go ahead. Why'd she seal it to begin with? Why wasn't it there to begin with? Because if all these files weren't there because the clerk is such a moron, then is this the clerk's fault too? Probably. And then she changes and says that you can put the Frank's memoranda back on there, but it's going to be filed as confidential because they didn't do the right thing. They didn't redact what they were supposed to. And then where she had ordered, it's like a game of chicken, I swear, where she had ordered the clerk to remove the motions by Rosie and Baldwin, she's now saying, hey, go ahead and put them on there. Doesn't really matter. I'm still not going to do anything about it. Still don't care. They aren't attorneys. They're not the attorneys on record. So this was 2 days ago. It was kind of a big deal just because she's throwing everybody under the bus except for herself. She literally takes no accountability. And then she gives herself a pat on the back for creating a website that she never created. So it's bad clerk, good judge. Bad clerk, good judge. Do this forthwith. So that's that. So then, of course, the clerk is starting to work on putting all those filings up. And we have a new, I don't know if I want to go there yet. Do I want to go there yet? Maybe we'll go here. We'll go straight to here because this is one of the things that she has to have unsealed. So we'll take a look at this first. This is, You know, and you guys correct me if I'm wrong, but I swear that there was a letter attached. Hold on. I swear there was a letter attached to one of the filings in there that had a letter. One of the filings had a letter from an inmate. Is it not the same letter? Because then as I was looking around, but I ran out of time. So I'm like, maybe it was, but I swear that letter was already out, or a letter from another inmate was out. And I don't want to give you guys bad info, so somebody please tell me. I'm looking to see if I can find it now that I actually have this open on my... No. I have the letter they unsealed today, but I swear it was actually posted before. But I don't know if it's the same guy or a different letter. I remember seeing it too. Annie, and I just don't know if it's the same dude. Is it the same letter? It's a second letter from the same inmate. Hey, suspicious. Who said that? Tammy. Oh, it's a second letter from the same inmate. Maybe that's why I'm feeling so familiar. Got you guys. Okay. That makes a lot of sense. There we go. I wish I had pulled up the old letter, but I don't think that's important now because I think we had already read through it before. Back in the day when all these came out. That's why I'm like, I swear I have a letter. If these were actually filed correctly, it'd be really easy to pull it up. But since they're not, I can't actually tell you. But it's irrelevant, so I'm not gonna waste too much time on it. We'll go through the new one. Did Sleuthy put the old one on X too? Hey, Art of Deduction, same guy, and he wanted it sealed himself. I send you a Facebook message saying, oh, you did? Okay, sorry. I got done picking up kids, came back, got on the live. So here we are. Got you. Okay, well, we're gonna read it. I have the letters on the site, but I'm too far behind on newer documents. Okay, that's okay. That's okay. We're gonna read through this one because I have not got to read through this one. So we're gonna read it together. Maybe that's way too big. All right, there we go. Let me turn this off because all you guys are looking at is the side of my face. This case, I know, it's a case that just keeps on giving. All right. So I like the way that he puts this up at the top, like it's an actual court document, like the state of Indiana, county of Carroll, state of Indiana versus Richard M. Allen in the Carroll Circuit Court, cause number. Letter to court. I, Robert P. Baston, inmate at Westville's restrictive housing unit, was subpoenaed to appear in the above case number on Thursday, June 15, 2023 at 7:30 a.m. in the Carroll Circuit Court, 101 West Main Street, Due to the corruption and retaliation by Westville's restrictive housing unit staff and officers, I had to refuse to appear in the above mentioned court hearing due to my safety and fear for my life. I was housed in a cell just above Richard M. Allen's cell. Due to being a voice on how Richard M. Allen was being abused and mistreated by corrupt sergeants and officers and administrative staff and mental health professionals in Westville's restrictive housing unit, I was retaliated against and moved by orders of Warden John Gallipo, Captain Gary Lewis, and restrictive housing unit manager Mrs. Tracy Cornett. They might have considered filing this redacted, but that's just me. I was moved to restricted housing unit B pod, cell 201, after reporting Sergeant Brandon Williams and his officers trafficking contraband to inmates in the A pod to the Indiana Department of Correction Office of Investigation and Intelligence, the Internal Affairs, in a recorded interview on April 28, 2023. A recorded interview. 5 days after the interview, on Wednesday, May 3rd, 2023, at approximately 7 a.m., Sergeant Brandon Williams and his officers while I was in full restraints and leg shackles in Westville's restrictive housing unit receiving area on security camera will show Sergeant Brandon Williams ordering an officer to put my mattress in urine in a cell that I was placed in the night before without a toilet and running water in the cell. Security cameras will show Sergeant Brandon Williams slamming to the floor and violently breaking my foot and ankle, and then intimidating the nurse not to treat my injuries when Sergeant Brandon Williams had an ink pen in the stag vest that he was wearing, stabbed me in the elbow all the way to the bone. I then was placed in a cell 201 in B pod. Then at 10:05 a.m. on same date, Sergeant Brandon Williams gave no verbal command to cuff up at my cell 201 B pod and dropped the handcuff port in the cell door and sprayed pepper spray in the cell and then left me in the cell for 10 minutes, asphyxiating for air. I then was handcuffed and removed from cell out of view of security cameras and taken out in the hallway where Officer Quentin Davis was waiting and told Sergeant Brandon Williams and officers to hold me up while Officer Quentin Davis violently punched me in the ribs and stomach while a officer, Mr. Motts, kneed me in the face while Warden John Gullible, mental health doctor Monica Wayne, and Mrs. Bourne were watching the beatdown from outside Captain Gary Lewis's office. Holy shit. The nurse again was intimidated not to treat my injuries, and I was placed back into cell 201 B pod. I was placed on a strip cell, I don't know what that is, and a strip cell, and my personal property was taken when I eventually received my property back. My legal documents were either destroyed or lost or taken due to incriminating recorded dates and times. Some of those recorded dates and times concern how Richard M. Allen was being abused and mistreated by staff and officers. Holy shit. My personal property was left out in the hallway, unsecured, in Westville Restrictive Housing Unit, general population workers, and suicide companions for stealing my property. I recently received from the United States Department of Justice investigative report numbers. There 1, 2, looks like 3 different reports, but recently the U.S. Department of Justice has been in the news for mishandling complaints. The Indiana Governor's Office I can't ever say that freaking word, Ombudsman Bureau has also mishandled complaints on the Indiana Department of Correction and the corruption going on in IDOC facilities. The Indiana Department of Corrections Office of Investigation and Intelligence, Internal Affairs, is allowed to police itself and covers up excessive use of force, assaults on inmates by IDOC staff and officers. I've also been corresponding with the New York Times investigative reporter and her team at Yale Law School. I have been sending documentation and evidence too, but due to the corruption, my legal mail has not made it to its destination. So until this court can protect me and other inmates at Westville Restrictive Housing Unit and report the excessive use of force, assaults, abuse, mistreatment, torture, and retaliation from corrupt Indiana Department of Corrections staff officers, then I do not feel safe to testify in this cause. When a pattern can be shown of the above-mentioned issues by researching the named individuals mentioned in this court letter in the United States District Court, Northern District of Indiana, the 7th Circuit, that clearly shows a pattern of excessive use of force, assaults, torture, abuse, mistreatment, and very poor mental health treatment. Again, I have witnessed Richard M. Allen being abused and mistreated by Westville Correctional Facility, Westville Restrictive Housing Unit staff and officers that has affected his health and mental health. I, Robert P. Baston, inmate number, ask this court to report this corruption to the proper authorities to investigate it. Respectfully submitted and sincerely, Robert P. Baston, June 25th, 2023, Westville Correctional Facility. What do you got? Holy shit. Okay, so I know somebody here had to have looked up what this guy is in there for, right? What's he in there for? Hey, Defense Diaries podcast. What's he in there for? Well, this is why I want to know. Hey, the Rockaways. This letter needs more Odin. Crimes against children, child molestation, bad shit, BMath. Yeah, I'd say so. Not good stuff, but regardless, he has basic human rights. Well, absolutely. Not to say that he doesn't have basic human rights, but I also want to make sure that there's something that's very clear here. Richard Allen is not convicted of any of those things, as much as they would like to say that he already is and just lock him up and throw him in prison. He actually isn't convicted yet. What makes you think anyone looked into any? Because Sluthy, because I knew you were in my chat. No, he definitely doesn't gain anything from doing this. He absolutely does not. He would only gain more punishment, and obviously these guys are not going to treat him very well if those are the crimes that he was convicted of. I'm not surprised by that. Unfortunately, that's the prison system as it is. You know, we don't sit here on, you know, YouTube True Crime and say, you know, prisoners don't like child killers and child, you know, rapists. They don't. Crimes against children are really bad. And other inmates that think that they're above that tend to look down on them and punish those types of inmates. So, okay. So that leaves us to that. He will pay a huge price for that letter for a long time. Well, the other one was out. That's why I wanted to make sure it was the same guy, or if it was a different letter, because I was like, there was one that was already out from this guy. So it makes sense that he's now saying, like, I can't come and testify, because even just me writing down what's happening to Richard Allen, that causes a problem. Much less if I came to testify what would happen to me. Now, I think another really big thing is there a way to know if this was ever actually followed up on? Did anybody ever actually look into it? We can request some FOIA. We can do some FOIA requests to the prison on this guy's info and see what was done, because I think that matters too. He's saying, like, most of this should be on video. There's obviously a nurse that has been told twice not to treat this guy. Is this guy telling the truth? I think that matters. Because, you know, they went to court in June, and essentially just the warden shows up and the guards show up and they're like, oh no, everything's hunky-dory and perfect in our prison. We're wonderful. Okay, so something to think about, something to see if we can pull out some of the records for that. Just get some follow-up. Yeah, the prison, hi Jay Turner, the prison investigated itself and found no wrongdoing. They're great at their job. Which one, Kate? Which one? Hey, Fort Pittsbulls. That's what I'm wondering. If Kate, are you saying like he lied about Richard, or which? Oh, you guys, if you ever want to just start digging into our prison systems, they're bad. They're really bad. and we don't do anything to change them. You know, and then if you look into like what the oversight committees, you know, say, and it's like, we just want more money. We want more money, and then we'll make everything better. And then look at how many prisons are abandoned. So we have overcrowding in prisons, and then we have complete prisons that are just vacant. They're just empty shells of buildings. It's the craziest. It's the craziest system. It's like the whole thing needs a revamp, but you know, who am I? Hi, Delina. I'll give you that excuse. Yes, he was a known liar, and prosecutors handled this in the hearing. All right, I'll have to look back on that. Thank you for the heads up, but I'll take a look. I'll take a look. But I will probably end up trying to request some files on this guy and see what we can come up with. That's how we do it, serendipity. That's how we do it. If you're being accused of really bad shit, you get to investigate the people that are accusing you. That's how it goes. Hi, MB Inc. Hi, Anna. Carroll County New Jail is being built currently. What are they going to do with the old one? Leave it sitting there? Ooh, really? A lot of acid true guards in the Plainfield prison in Indiana. A lot of people are acting like we don't know exactly what happens to people in prison for crimes against children when it comes to how Ari's been treated in prison. Right. But the problem is he's not even convicted of it. Much less is he wrongfully convicted or rightfully convicted. We're not even there yet to even make that decision. Like, we can believe the prosecution. The prosecution investigated it. They're the good guys. Great people are too nice. Yeah, it's all about money. And then you got private prisons. Yeah, that's a whole nother life. That's a whole nother life. Okay, so we get this morning, and I'm going to say her name wrong. I always do. Carol Winicki. She's the one who filed the first writ of mandamus to the court. And so she had actually posted on Twitter to look for one that was coming out this morning. So I kind of kept an eye out to see what was happening. So this is a brief of, I hate this. And this is amici curiae. And everybody says it different, so you never know. But this is fun. This is funny because when I was watching the Defense Diaries podcast, if you guys aren't familiar, you guys should definitely be watching. But Allie, who is Bob's wife, who's also a defense attorney, was on there, and she was talking about amicus briefs. And she was like, if there's more than one, does it become amici? And so as soon as I saw that, I was like, hey, Allie, there's your answer. It's like amici curiae, the media coalition. So this is like a multiple. And we talked about this, so kind of break it down, simplify it. The people who are wanting to be heard in the writ of mandamus, they have to essentially request the Supreme Court to say, hey, we over here believe that we have a right to be a part of this. And so we're requesting to be heard. And that's what this is. So the last one was, we went through it. It's the Public Defender Council of Indiana, and they requested to be heard, and they actually got accepted. So they are now part of the filing. And that's the second writ of a mandamus filing. It gets confusing because there's two. Right, yeah, so, right, yeah, it's kind of chaotic because there's so many. So, yeah, the writ of Matt Damon. That's okay, because somebody put on Twitter earlier that it was the writ of mandamus, and I it cracked up like a school kid. So they're essentially saying, hey, we believe that we should also be heard, and here's our reasons of why we think that we're important enough to be heard when it comes to this writ. This has not been approved as far as I know. If anybody else has seen differently, I did not see that before I went live, that this has still just been submitted to the Supreme Court to say, hey, here we are, we want to be heard. If you guys know differently and it has been approved or denied, let me know. We're going to go through it. I'm on replay speed. Where can I find the documents, T? Idaho Charlie. There's a few different places. So most of the Facebook groups will actually post them. And if you're on Reddit, there's a subreddit called Delphi Docs, and they're very good about putting stuff up quickly. You can find them there. Or I can put the PDFs. I can put the PDFs in the chat too. But there's a lot today, so. But that's probably the easiest place. I typically, and if you want to just pull them straight from, see, that's tough. So if you go to my case in Indiana and you look up Alan Richard M., you'll have 3 different cases there. They've done a really good job on the Supreme Court filings, the 2 writs of mandamus, where the links are actually clickable and you can download the PDF yourself, which is ironically, is part of the whole writ on the first one is that her docket, or her case file looks like crap and you can't do anything with it. So it's kind of ironic because they're trying to make sure that everything is super clean and you can go in and get what you need. It is not the chronological case summary, but it's the my case summary. I'm overcomplicating it, I think. But there's quite a bit of places. If you're in Facebook groups, most Facebook groups posted them. If you're on Reddit, go to Delphi Docs. They're the ones who normally post them the fastest. Right, it is. That's what they're doing. So it's they're trying to mandate that this happen. That's what they want. Or there's also a writ of prohibition, which is trying to make sure that this doesn't happen. So we're trying to mandate that this happens. So you're right, though. It is the same origin. Anna's not feeling good. Oh no, Anna. Yeah, everything in our judicial system comes from Latin words. It makes it a little harder. Okay, so instead of naming all of these, they essentially come together as the Media Coalition. So it's like the Indiana Broadcasters Association, the Hoover State Press Association, the American Broadcasting Companies. There's a whole bunch of different journalists. And like immediately when I saw this, I was like, this is Baldwin when he walked out and he was like, journalists need to start being journalists. You know, I was like, well, I guess here we go. This is a step in the right direction. So introduction, people in an open society do not demand infallibility from their institutions, but it is difficult for them to accept what they are prohibited from observing. Amici respectfully urge the Supreme Court to grant the petition because the status quo threatens key democratic values and trust in the criminal justice system. In seeking public access, amici act as surrogates for the public. The United States Supreme Court has aptly explained the media's important role. In society in which each individual has but limited time and resources with which to observe at first hand the operations of his government, he relies necessarily upon the press to bring him convenient form the facts of those operations. Great responsibility is accordingly placed upon the news media to report fully and accurately the proceedings of government, and official records and documents open to the public are the basic data of governmental operations. With respect to judicial proceedings in particular, the function of the press serves to guarantee the fairness of trials and to bring to bear the beneficial effects of public scrutiny upon the administration of justice. This is just essentially telling you, as the public, you have the right to be able to know what's happening in the courtrooms. For people who do not have time to go sit in a courtroom and just watch the entire trial, we count on the media to tell us a synopsis of what's happening and to have the understanding of what's being filed and what isn't being filed. Hey, Mandy. Good to see you. JD Coop. A writ of mandamus is more of a, hey, look at this. It's basically saying if the Supreme Court reads this, they would agree. If they don't take action, harm will be done. That cannot be overturned. I concur. Naming my firstborn Amakai. So this is just, hey, you guys, as regular citizens, you guys are counting on us, the media, to put out what's happening in the courtroom, and we can't do that when a judge like Francie Gull is hiding everything. We can't tell you anything. So the trial court's orders which exclude judicial records from public access without process or remove them from the CCS altogether significantly restrain the media's news gathering activities regarding a matter of the utmost public importance. If the trial court's handling of judicial records stands, the media cannot serve its pivotal role in the democratic society, and the public will remain in the dark. Amici respectfully request that the court grant the petition. Let's see what the footnote is. The Media Coalition acknowledges that the trial court ordered that certain documents be made public on the docket per its order issued on November 14, 2023. While the order resolves some of the access concerns stated in the petition, the order does not resolve all the concerns. And it appears that the mere filing of the petition spurred the order. The petition remains important in ensuring complete adherence to the access rules, as well as to address the issues that remain unresolved by the order. So the petition remains important in ensuring. So are they trying to say that they're going to take away the petition, that she's worried that Amici respectfully request the court grant the petition? Well, that's the writ of mandamus. All right, I'm going to keep reading, so maybe it'll kind of clear that up for me. Trial court's handling of court records is contrary to Indiana public policy favoring open government and the Indiana and United States of constitutions protecting access rights. Correction of the trial court's errors is necessary to ensure government transparency and accountability, which is especially critical in criminal matters. Explaining that the press is the handmaiden of effective judicial administration, especially in the criminal field, and a guard against the miscarriage. Tiny human, hold on 1 second, you guys. Okay. Give me 1 second, you guys. I'll be right back. Okay, sorry guys. He wanted me to teach him how to make a bologna sandwich. So I told my daughter she's gonna have to help with that. She's like, that's a lot of work. Hi, unraveling. Yeah, he always comes in. Let me get a sandwich too. Yep. What did you? Yes. That's the too long didn't read version. Is they're just saying the stuff she uploaded is cool, but she needs to be cooler and upload some more stuff and stop being so stingy. Do you think the fact that she allowed cameras that one day for a specific purpose and never again can be used against her? It's not like the courtroom blew up. Everyone went home early. Well, I think that she did it on purpose. Without a doubt. I think she purposely knew that what was going to be happening, so she purposely had the media come in. I think that there's a bit of a struggle on the timing of the recording, because she says that essentially that she told them they couldn't record until they were, like, court was, in session, when it was on the record. And that's when they could record. Well, they're saying that they were allowed to record a half hour before court was in session. And because court was supposed to start at 2, they had started recording at 1:30. And she's saying, no, they shouldn't have actually recorded anything until, what, 2:40? I don't even know the times, but you know what I'm saying. I think it was 2:40 when she finally went in the room and was on the record with her 3 minutes of unexpected events have occurred. And now here we are, it's out of our control, you guys, it's out of our control. So she now banned cameras based on that there was recordings happening by the media that she did not authorize. And that's because of the clip that was put out of Brad Rosie when he went up to Kathy and, you see him go in and then get her and then go to leave. So she's saying that should not have been recorded and that shouldn't even be out there. Now, I think that's just an excuse because she doesn't want them in there anyway. There's no way in the world. She doesn't want to put her stuff on the record. She doesn't want to put her stuff in the docket correctly, much less does she want actually anybody to watch what she's doing. There's no way. No way she wants cameras in there. So that was perfect for her. Now, how are they going to go about fighting that? I don't even know, because the Supreme Court passed, I think it was May 1st of 2023, the Indiana Supreme Court passed that they could now have cameras in their courtrooms at judicial discretion. So ultimately, it's up to her anyway. So even if they go back in and they try to argue like, hey, you told us we could record a half hour before court was supposed to start, she's just going to say, I don't really care what I told you. I don't want cameras. And it's up to my discretion. So see you later. Get the hell out of here. And it's like almost mute. Like it just gives her like a good, I don't know, an excuse. Like whatever she thinks that she needs to make that ruling. Not yet. I honestly wouldn't even be surprised if something does happen where a federal court has to take over. If a federal court takes over, we'll see nothing, which is almost better. It's almost better because at least we know it's out of the hands of the people that are making a mess of it, but then there's no visibility for us anyway. So I don't know. It's a double-edged sword. But she did. She did. She loved being recorded at the courthouse. That was her last bit of fame she was going to have. We're talking about Amber Heard, anybody who's not actually reading. Okay. Where was I? The trial court's handling of courts. Yeah, so it's contrary to what the actual state says, that they're allowed to have access to all of these documents. We've talked about this a few times, but to just summarize it, if she wants to seal something or she wants to have something marked as confidential, she has to have like a placeholder. So when you go through the list, you'll see like Frank's motion, sealed, confidential, whatever she marks it as, with whatever rule of law that she's using to seal it or to make it confidential. So it would still be there. It's just not accessible, so that it's all straight. It's all clear. It's all clean. And that's what she's not doing. She's just making it a mess. So how does she even know where all this stuff is? What does it look like for her on her end, I wonder? Hey, MK. Yeah, well, and she does not take any responsibility. Just like the very first motion we read today, she's literally blaming the clerk of the court and then giving herself kudos as the court for creating a website. You think Fran C. Gull sat down and created a website? I don't think so. That she can't even finish reading the Frank's memorandum. She don't have time to make no websites. I don't know. Annie, I go back and forth. Let's make a poll. Let me open the chat. Let me open my video real quick and I'll make a poll. Because I seriously, I go back and forth. All right, let's see what you guys think of that. But if you think that she will, yes, her name is really Fran Siegel, so I make sure to say it every time I can. Yep, Fran Siegel. Aw, Dark Arts by Adrian. Thank you. Thank you for everything you do. What do you think Assign keeps her? Are there any other measures to stop or replace her? Not really. They would have to continue to, they'd have to appeal it. The problem is going to be, if they keep her, everything is going to be pretty much done with the Supreme Court level. Are there other legal tricks? I'm sure there are. I'm by no means a lawyer. So I think that would be a really good question to ask, like Bob and Allie on Defense Diaries, or even on the Prosecutor's Podcast. They would have more idea of what little loopholes and stuff there are. But from my understanding, that's going to be pretty much it for the Richard Allen side of it, if they don't remove her. Part of me thinks they will, and then the other part's like they probably won't. Because it's a really bad look if they do, right? It's a really bad look if they go in and they remove a sitting judge from this case, number one. Do you think they'd call her in the office and be like, hey, Fran Siegel, we're going to give you the option. You can either recuse yourself or we're going to do it for you. Pointer lover. T, do you know of anyone that is in the know of back dealings of judges in that state? Like, who's got dirt on who? Oh, I'm sure there's plenty. I don't know the judges in that state, but I'm sure there's plenty of dirt going around. Yeah. Yep. So that's another thing. It's better whether you like the judge, whether you don't, whether you like the attorneys or you don't. It's ultimately better for Richard Allen's constitutional rights to keep his attorneys of choice and get rid of the judge. Because the judge is simply there to rule on the judicial matters. They're not there to actually determine guilt, whether he's guilty, not guilty. They're not there to determine whether they like the attorneys. That's not their job. So they don't have to know any of the evidence going in. You can literally say, hey, you judge are out today, and now you judge are in. And the same thing should really happen, as long as that judge is qualified to handle a criminal case, right? It's different, though, because the defense attorneys they're part of Richard Allen's defense now. The judge is not. So in my personal opinion, no matter who you like or who you don't like, it's more imperative for Richard Allen to have his attorneys that he chooses. Now, on the flip side of that, if he has those attorneys and he loses, then he's going to cry wolf and be like, oh, but you should have got rid of those attorneys. They bullied me. They did whatever. Who knows what he's going to do? He's not going to just sit down and shut up. He's going to use it for an appeals process. So this is my struggle, is if I got to be the Supreme Court justice who got to make a decision about this, what I would say is Fran Siegel is removed from this case. New judge is coming in, hopefully unbiased, but it is what it is. And they would have a hearing to determine if there was or was not gross negligence, to the effect that it would hinder Richard Allen's defense. Like a totally different person coming in and making that determination, and then we'd go from there. That's what I would make the decision of. But obviously, I just hang out with you guys on YouTube. I don't get to make that final decision. I don't think she had to turn the transcripts in today. Let me double check the date of that. I don't know what date she had to turn those in, because there's so many moving pieces right now. Everything's kind of convoluted and kind of overlapping, but I think today was only the day that she had to respond to the first writ of mandamus, which she did. We have not read yet, but she did respond right before cutoff. So the second writ of mandamus, she has until the 27th to file any additional documents, but then the Supreme Court did put out, let me see if I can find it really quick. If not, we'll move on. The Supreme Court did put out the order that she had to motion for transcript, motion for extension of time. Let's see what this is. No. That she had to either submit the transcripts of the October 19th hearing, or she had to give them a legal reason why she was not putting those out. And I don't remember what date that was. I think it was the 27th also. You guys in here and tell me if I'm wrong. The 27th is when all the responses need to be in for the second writ of mandamus. That's for sure, but I don't know if she gave a specific date for the transcripts or the reasoning behind the transcripts. Let me see if it's this one. Nope, that was her extension for the first one. Or the ruling for the first one. And then she got the extension till today. She got 10 days. Let me see if any of you guys have answered. Yeah, 27th. Well, yeah, but I don't think she's gotten where she is because she doesn't fight. I think she's power hungry. That's why she's been going for a spot on the Supreme Court of Indiana now for a while. So she's not going to just back down to these, measly little defense attorneys that did so many bad things. It's just not going to, she's not going to do it. That was the motion. I'm almost positive she has until the 27th to produce that. But I might be wrong on just the transcript part. If somebody ends up pulling it up and figures it out, go ahead and let us know. But I'm almost positive she has until the 27th for that as well. Okay. Let's keep reading through this. Let me see where I was. Consistent with these principles, the General Assembly expressly recognizes Indiana's public policy that all persons are entitled to full and complete information regarding the affairs of government and the official acts of those who represent them as public officials and employees. Indiana Code. Further explaining that the Access to Public Records Act will be liberally construed to implement this policy, and that the burden of non-disclosure falls on the public agency. Access to court records, Rule 6, likewise presumes openness and requires compelling evidence to overcome this presumption. Apart from well-reasoned policy considerations, the public interest in accessing judicial records has constitutional dimensions. The media, as representatives of the public, are presumptively entitled to judicial documents and proceedings under the First and 14th Amendments of the United States Constitution. It is clear that the courts of this country recognize a general right to inspect and copy public records and documents, including judicial records and documents. The Indiana Constitution, similarly, and perhaps more so, protects public access in key news-gathering activities. It gives you your citations. In light of Indiana's constitutional protection of the free interchange of ideas, this court has assumed that a material burden on news-gathering ability could violate the Indiana Constitution. So they're literally just citing different times that the media has been able to access all of these things, and that the Supreme Court has already put that in motion. Like to look back at their own cases and say, hey, we deserve this. Considering Indiana's policy favoring public access and the constitutional implications of restricting access to judicial records, the public and media interest in accessing judicial records is not something to be taken lightly. In disregarding the access to court records rules and trial rules, the trial court has improperly restrained or outright prevented the public's and the media's access. The trial court's violation of the ACR and trial rules significantly undermine the public access rights and the media's news-gathering function. As explained in the petition, the trial court improperly removed publicly filed documents from the CCS and excluded others from public access. Amici expound upon the troubling implications for the public and the media. First, the trial court's removal of filings from the CCS is never allowed, and for good reason. The trial court lacks any authority to remove filings from the docket. This is true even if the trial court deems a filing improper. Even improper filings are public record, and the trial court's finding of impropriety does not strip the filing of its public importance. The Franks Memorandum is a key example. Franks' filings attack probable cause affidavits by asserting that the preparing officer misled the court regarding the existence of probable cause. A criminal defendant's attack on the foundation of his arrest, even if somehow improper, is newsworthy and deserving of publication. Unilateral erasure, I don't know what that is, of filings, erasure, that's like removing, of filings from the public record erases history. That's pretty impactful. Second, the parties cannot just agree to exclude public records from the public access. The ACR rules expressly prohibit. The judge is the primary representative of the public interest in the judicial process and is duty-bound, therefore, to review any request to seal the record or part of it, instead for requests to prohibit public access to records that otherwise would be publicly accessible. Notice and public hearings are required. The public hearing provides necessary sunshine. Its absence cloaks the judicial process in secrecy. That's another one that's big. The public hearing also ensures that the presumption of access has been overcome before a record is excluded. This process ensures that matters of public concern stay public unless extraordinary circumstances warrant otherwise. Holding that the court improperly delegated its duty to determine whether records should be sealed to the parties, explaining that the parties to a lawsuit are not the only people who have legitimate interest in the record compiled in a legal proceeding. The public concern is especially acute here, where the improperly excluded records are from one of the most high-profile criminal cases in Indiana history. Third, the trial court's decision to upload public documents to a zip file online rather than make them publicly accessible on the CCS is woefully inadequate substitute. Oh, that wasn't her fault. That was the clerk. She told the clerk to do it, and she just didn't listen. Damn clerk. As explained in the petition, the 118 documents in the zip file were filed over several months. Each document in the zip file is dated 6/27/2023, and the file names have no clear identifying information. Petition PP 45. Even if the files were labeled clearly and organized chronologically, however, that would still be insufficient. As an official record of the trial court, the CCS is where the public goes to get information about cases and to view court records. A central and consistent repository rather than a piecemeal approach, which is literally what that is. It's like click on it and then see what you can figure out. Good luck. Have fun. Some records are located at X, others are located at Y. Fosters meaningful public access. Online access to courts is one way to improve accessibility. Citing my case as an example of an online portal that fosters a more efficient and transparent legal system. The trial court should be required to make the 118 documents publicly available on the CCS itself. All right, let me see where you guys are at after that section. Choose your own adventure. Well, that's really what it is in this case, because you have no idea. Like, I want to go find a file, and I'm like, shit. If I didn't rename it myself, I wouldn't have any idea what it was. Yeah, she is the ruler of all rulers. I expect you to understand that, Christine 777, forthwith. It has been so ordered. I think they did that to keep track of who was accessing them, not sus at all. Oh, yeah. Oh, that's an interesting point. They're like, how many times are people actually coming in here? And who's actually coming in here to get them? Hey, Lauren Hill. My very good friend is one of the lawyers that filed the papers for Brad and Mr. Baldwin. Finally remembered my login. Hi, from Logansport. Welcome. I don't know which friend of yours is one of the attorneys, but I'm a big fan of most of them, so it's really neither here nor there. And how do we blackmail them? Ha ha ha. She would fit in great on that show where they all wear red cloaks. Kim Jong-Gul. I'm a big fan of Hennessy, but I also like, I say her name wrong, but I really like it. I really like her. She's a Kara Winicki. I know I say it wrong. Oh, Mark Lehman. Yeah, he was a big part of that too. I know, but I can't say her last name, Sleuthy. But, you know, there's so many words I can't say. I can't add more to my list right now. I'm too busy. Too busy. All right, let's go to the next section. Granting the petition would serve the significant public interest in this case, and denying it would have adverse consequences. Well, I don't think that there's anybody here who's going to disagree with that. The significant and legitimate public interest in this case is undeniable. Already, the trial court has received numerous requests for access to judicial records and for cameras in the courtroom. The public interest in this case is not going away anytime soon. No, and she's actually making it bigger than it used to be. I mean, it was really big at the beginning, and then it kind of died down for a little while, but now she's really ramping it up. She's really ramping up the interest because people are typically on one side of the, you know, on one or the other side of the fence here, whether she should stay or she should go. Speaking of, let's check the poll. Ooh, you guys think that she's going to get removed? 67% think she'll be removed. 34% don't think she will be. I just don't know. Christine G. I think it would be in the best interest to have her removed at this point. But, like I said, I'm nobody. Hold on, let me read something real quick. Okay. Frank sent me about Baston. The record seals based on its determination that he had pending criminal matter, and we sustain Baston's assignment of error. The judgment of the trial court denying Baston's application to have his records sealed is reversed. This matter is remanded for the trial court to determine whether Baston is otherwise entitled to have his records sealed. Okay, so he wanted them sealed because he still had pending court matters. But now it probably doesn't matter. So they denied it at first and then overturned that and then sealed them, which is why we didn't see it. I wonder if his court matters are now done and that's why she can unseal it. But that, I mean, that is an interesting point, that was sealed because he wanted it sealed and he fought to have it sealed, or his attorneys did. That's exactly how I would feel too, anything goes. I'd be like, no, I want her to be removed, so I need to vote yes. Because if we put it out into the universe, then we're good to go, right? Good things will come to us if we put it out into the universe. I think they will get rid of her because the world is watching. It's going to be a tough one. It's going to be tough. The other thing is no matter which way it goes, I feel like there's like half the YouTube world is going to be on fire no matter which way, because the other half is going to just try to poke at the other half no matter what. It's just going to be, it'll be chaos on the YouTube streets for a hot minute. I'm like, see, I told you so. I told you so. Shit, now I don't even know where I was. Was I down here already? Public interest is not going to go away anytime soon. Unless the petition is granted, the integrity of the judicial system is at risk, stating that secrecy of judicial action can only breed ignorance and distrust of courts and suspicion concerning the competence and impartiality of judges, and free and robust reporting, criticism, and debate can subject the criminal justice system to the cleansing efforts of exposure and public accountability. The history leading the relator's arrest, coupled with the nature of the underlying alleged crimes, the murder of 2 children, underscores the need for transparency. The death of any child is a matter of the keenest public interest. The Delphi community and the broader public deserve access. Even if access to every judicial record is not ultimately granted, the ACR rules must be followed to protect the public's trust in the system and to ensure fair proceedings. With respect to the judicial proceedings in particular, the function of the press serves to guarantee the fairness of trials and to bring to bear the beneficial effects of public scrutiny upon the administration of justice. Granting the petition would facilitate key news gathering activities, ensure that access and process prevail, and promote the public confidence in our judicial system. Amici respectfully request the court grant relator Richard Allen's verified petition for writ of mandamus and prohibition. So, to sum it up, I think it's very important to know that there are people that are fighting for the transparency of this case and obviously other cases, because they could just let this go. And I think that would be a really big mistake. And I think what they're doing too is kind of covering their own asses because the world is watching. We expect that somebody go and fight. Somebody who has the power to fight should be fighting. So I'm happy to see that. Now, since she's already made the determination that she is putting this stuff back on the record, and that it was all the clerk of the court's fault because she just didn't do what she was told, but Gull was busy making websites, I'm not sure how far that's really going to go. Is it going to end up being mute? And that's only one of the writs, though, because the other writ is different. It's not about this. Hi, Professor Kate. They've gotten quite a bit of attention from the lawyers on YouTube, and they all seem to think at least some shenanigans are happening in Delphi. At least someone has to be aware. Right. Well, and you're getting the attention of attorneys for the Public Defender Council is stepping in, which is also where Hennessy is from. So, I mean, that's, take it or leave it. But that's a big deal, and they're not wrong in what they're saying. And how she picked the new attorneys is not the correct procedure to do it. And whatever happens with the way that she's doing things, if you guys aren't familiar with like all the court stuff, everything is essentially based on precedent. So they take all these cases are being cited to prove that there's already precedent in these matters. Like, hey, she can't do this, but if the Supreme Court then rules that she is allowed to do this, that's going to change things for the future and what other judges think that they can do. A judge can't go around picking a defendant's attorneys for him. That's not the way it works. So if that stands, then that sets precedent for other judges to be able to pick other defendants' attorneys or to make findings in behind closed doors without ever telling anybody why and then hiding the transcripts for it. I was going to say, I agree with that, but how is there a documentary being made with a gag order? They leaked info just prior to it in 2022. Yeah, essentially. Somehow, some way, this case has found a way to move around the Idaho 4 case regarding law enforcement and prosecutorial suspicion. Well, I think there is all of that. It's just nobody cares. Like there's almost like a, who do you tell? So I think this is maybe a really long way to go about it, but at least it's opening the eyes to the world and to people in that area of what's actually happening. So this has not been approved. They have not actually said yes that the media coalition can come in and fight for their spot in this case. Unless you guys, like I said, unless you guys have seen something since I've been live, I'm not aware of. As of right now, this is just the request to the court saying, hey, we believe that we the media should have a say-so in what happens here. because it affects us and it affects the general public. And to me, this is journalists being journalists without being like, I'm going to go on the news in a beige shirt and tell you guys what I think of the case. This is actually what they should be doing, is fighting to make sure that our constitutional rights are secured via, the media. So this is a positive on the back end, in my opinion. That's why they need to reinstate Rosie and Baldwin. I think so. I think that they're going to have to weigh it. They're going to have to weigh the appeal, because I think this whole situation has completely set everything up for an appeal, for many, many appeals. Not that there wouldn't be appeals anyway, but a lot of times those appeals could just get knocked down. Like, sorry, we don't need to hear that, unless it's a death row. Unless the person is sentenced to death, then there's automatic appeals all the way up to the United States Supreme Court. That's just how it goes. And that's why that, death penalty cases typically actually cost a lot more money. People think it actually saves the country money because they're being put to death, but it actually costs the country more money, because most of those people who are sentenced to death aren't paying for their own attorneys. The states are paying for them, or the federal courts are paying for them. So, but in this circumstance, it's not a death penalty case. So it's going to go to appeals, but they could be denied. But the way that this is happening, it's setting it up for a possible appeal on either situation, either way. So I think they have to weigh, I think the Supreme Court has to weigh his constitutional rights first and foremost. And then the judicial overreach. Does Fran Siegel is she committing judicial overreach, or is she within the means of what she's allowed to do? That's really hard for like us just as laymen to be able to say yes she is, no she isn't, because there's a lot that goes behind that. In my opinion, as an outsider and somebody who understands a tiny bit of the law, I think that she has committed judicial overreach in multiple different categories, because I followed a lot of cases for a long time. This is really unknown territory. I've never seen anything like this. I mean, I've listened to a lot of attorneys on different things too, and they're like, I've never seen anything like it. So, and they live it. I don't. Hold on, let me see. Proof the said photos were out exists. Proof they are actually what's described does not yet exist. What more? Show me the money, prove it. I think I may have missed a comment that goes along with that. But I definitely think there was photos that have been out for a while. I cannot prove yet that they are the exact same photos, but I will damn well try. Okay, I think Gull's response here created the perfect opening to argue and show clear example of bias against the defendant by saying the Franks memo was sealed because... We haven't got there yet, Sleuthy. You're jumping ahead. Jumping ahead. Yeah, she was noticeably biased from day one. Then she's like, don't believe I'm biased? Let me prove it. Yep. And I say that, and people are like, well, you're like pro Richard Allen, and like you like Richard Allen. I'm like, I don't give two shits about this guy as he is him. I give two shits about him as he encompasses what could happen to anybody else. Could happen to me, could happen to my kids, could happen to my husband. That's where my concern comes in. I don't know if this guy is innocent or guilty. I don't know that yet. I really still don't. You can ask me today, and I'll probably tell you that I think that he's probably innocent. You ask me tomorrow, I'm probably going to tell you that I think that he was involved, that there's other people involved. I consistently change my mind about that, but what I will not change my mind about is his constitutional rights that are, in my opinion, are being violated. So that's where I'm at. And I know that like upsets people because they want me to be like on one side or the other, and I'm just really not. I just can't be. Okay, so we were talking about with the first writ of mandamus that was filed that France Siegel had to submit her response by today. So right before the closing of her being allowed to actually submit anything, her attorneys dropped this in. So just a little refresher in case anybody doesn't remember, the Attorney General actually refused to represent Francie Gull in these Supreme Court hearings. They said, no, sorry. So she had to actually go get herself counsel, and they're the ones who are submitting this on her behalf. So this is now the response to the first writ. Remember, we have two, and that's why I said everything kind of overlaps. But this is to the first one. We'll just go through. So there's a table of contents, blah, 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 blah. I'm not going to go through the table of contents because we're going to end up reading all that anyway. And we want justice for Abby and Libby the right way. And I know that probably pisses the families off. They're like, stop talking about him, and he's not a victim. And I get it because like their loved ones aren't here. But I just don't know. They'll never truly ever stop. So once again, like he'll be able to appeal regardless. And they'll go, okay, well, Richard Allen's going to appeal, or, depending on his sentence, whatever his sentence is, maybe he'll be up for parole at some point. Who knows? But they're going to have those things that are going to happen anyway. What's happening now is going to almost, in my opinion, solidify an appeal no matter what happens here, because she cannot, like a approved, guaranteed appeal, possibly new trial. And that those families are going to suffer. Hi, Schmeed. That's right. I do want to visit. It's funny that they automatically accept the filings under seal in every filing besides the Franks motion. It's on the court for allowing the unredacted version to be posted. Right, that's probably also the clerk of the court. She screwed up again. She's so bad. I hope she writes a book. I'll read it. I predict it will come down to the U.S. Supreme Court ruling. When broken down to, let's say, colors red and blue, there are 5 red, the majority, and 4 blue. Gull will stay on case in a 5-4 ruling. Oh, I hope it's opposite. K-Bird, I hope it's opposite. I'm glad that people are learning how important the Constitution is, and sorry that it takes a gross negligent judge like Gull to make that happen. Right. And that's like something that I end up getting in these conversations with when I'm in other people's chats. And I don't, like I said, I don't care about anybody's opinion, whether they think he's innocent or guilty. I could care. It doesn't really affect me. It frustrates me that they're like, well, they did commit gross negligence, and the judge had every right to remove them. And I'm like, well, what did they do? And then you don't get the same answer from anybody. And you guys know why that is, that you won't get the same answer? Is because we don't actually know. So maybe they did commit gross negligence. And maybe Francie Gull is right in being able to remove them. But she didn't go about it the right way. Because if she did, we would all be on the same page, that this is exactly what they did wrong, how they did it wrong, when they did it wrong, and why they did it wrong. And you don't have that. And that to me shows, and should be the bottom line, that we do not have the right answer. We don't know what they did. So whether she's right or wrong, she didn't do it the right way. And that's her job. And the second one that really frustrates me is they should have gone out and fought for their client then. This is their fault. And it's like, she gave them a choice and they made the choice. It's her courtroom. If you guys see how bossy she is, she's the one that makes the rules. It is her courtroom. She's the judge. It shouldn't have been an option. It should have been, hey, in the email on the 12th, we're going to set a hearing for the 19th. Bring your witnesses, bring your paperwork, bring what you got. We're going to go through and determine whether you guys should actually stay on this case or not. Come prepared on the 19th. Go into the hearing, go into the courtroom, lay it all out, and here it is. And this is why the judge determines that there was gross negligence or not. And then it's on court record. These shenanigans are exactly what the problem is. So it's not that they did or didn't. It's if they did, what did they do? How did they do it? When did they do it? But because you can't go into these other chats and ask that question, because nobody actually will be able to give you the same answer. That's what I want. Tell me what you, well, they'll give me an answer, but it's not going to be the same as anybody else's. So that's where I stand. It's like, if she had just done it right, none of us would be questioning anything. I mean, we might question it a little bit, but we wouldn't be where we're at now. That's the other big fight too, is if Rosie actually withdrew or not. But yeah, optics. And it's funny because there's a channel called The Unraveling that was posting pictures of like other people who've been arrested, other people who've committed horrendous crimes, and how they're being like walked into courtrooms. And it's ironic the amount of, or the lack of amount of shackles or handcuffs or guards that are around them. And yet, Richard Allen comes in and they've got him just, shackled with his taser, connected to him so they can zap him whenever they want to. And they were talking about optics, so it reminded me of that, because that's exactly it. It's the optics. They want people to think he's really bad. He's so dangerous. Look how dangerous this man is. We have to essentially tie him up to bring him to the courtroom. Jay Turner, I so agree with you. And if you guys aren't familiar with the channel MB Inc., maybe one of my mods will drop it for you. He posted a video today, and it shows like all the different times, like from Google Earth and Google Maps, like of the all the cars that were in, that are associated with Richard Allen's house throughout that time lapse. And I'm like, well, that's interesting. Could you imagine like all the cars that are in that area? Like when they talk about like Brian Koberger and his Elantra, and how the whole thing is that there's like 20,000 of them in the area or whatever. They can't even actually determine that it was his car or Richard Allen's car. It's just a car that looks, that could be it. Could be it at 127 going an odd direction, because it doesn't even make sense that he goes that way. But yeah, BK's in suits. RH got suits. Yep. Is anyone thinking he will cut a deal and give up more people that might be involved to get a better deal? If you go with what the attorneys are really kind of pushing, is that they actually believe he's innocent. They don't think he has anything to do with it. They think he's been completely railroaded. And to me, that is not somebody who's going to say that there's a deal, because there is nobody else involved if they think that he's innocent, right? They think that he doesn't actually know. Hey, Lee, welcome. There's supposedly bombshell evidence. And that's another thing. Like, everybody keeps saying that there's bombshell evidence that we don't know of yet. Maybe there is, but it doesn't seem that the defense knows about it either. And that's another big thing, is that they were going to have to go and give them all of the discovery, everything they had, by November 1st. And there's no way in the world McClellan was ready to do that. He absolutely was not ready to do that. And they can't just go, it's not like Perry Mason. They can't just go in there and create some type of bombshell evidence and be like, look at what we found, and here's the knife with your fingerprints on it, like, that's not real life. That would already have had to have been disclosed to the defense team. So what, I mean, were they going to wait till November 1st to disclose it? Their big bombshell evidence? It just doesn't add up to me. And if they had big bombshell evidence, it would have to be like bombshell. It would have to be like they have the murder weapon that is connected to him. You know what I mean? And then why would you have... So, I don't even know. Because everybody keeps saying, like, all the insiders who have all the inside information. And I don't have sources, so I just kind of I fly by the seat of my pants over here. So take it for what you want. Video evidence. Then why would there not... Why in this Frank's memorandum would there be anything that would be like pushing this narrative of there is nothing that ties him to the crime scene, if they know that there's something that ties him to the crime scene? Yeah, they want him to plea. They don't want him to go to trial. He really is amazing. The channel is it's so simple and easy. So like for people who just want like the straight to here's what it is, I always recommend his channel because that is not me. That is him. Rumor is the big evidence was found during the search warrant in his house. But then why do we have them saying that there was nothing that tied him to it? And supposedly, see, this is where we need like the full depositions. Supposedly in these depositions, we're being told that these guys said, yeah, there is nothing. There is no DNA. There is nothing. There's no electronical anything that ties him to it. So whatever they would have that would fall into that, then the defense didn't have it at the time that they wrote that memorandum. Keep in mind, they need to prove the aggravating factor of kidnapping. Can you foresee how bad Nick is? Has he done a murder trial now yet at all? MB Inc. Maybe I can grab it for you, or maybe one of the wrenches will grab it for you if they. I think they put it in here already, but not necessarily, because what also happens is you have the PCA, but if they're still say they I'd have to look at the exact date of the PCA. Because they arrested him, the 28th, right? And so the search warrant was the 13th, and they arrested him 15 days later. Let's just say they found a knife in his house, and they sent it to the lab for testing. They wouldn't be able to tie it into the PCA yet because maybe the testing hadn't come back. Does that make sense? So some things yes, some things no. It's essentially the PCA is some of their best evidence that they have at that time. And it's almost like a chess move. So they'll do, some will put anything and everything they have at that exact moment because they want to get the arrest. Other ones will hold a little bit back. They'll put in just enough to kind of get that they know they can get the probable cause to get the arrest, but they don't want to give up all their evidence yet. All right, let me see what you guys are saying here. Hold on. 12 in total, what? There's more phone evidence from Libby's phone. Right, but okay, well, we know that because we only have a 2-second clip, if even, and then a millisecond of audio, and we know it's 43 seconds. So yeah, there's definitely more phone evidence. But the more phone evidence isn't going to immediately tie to him, because if it did, they would have arrested him 6.5 years ago. So that means that there's going to be room for reasonable doubt on why whatever they have on that audio video doesn't directly tie in. 12 in total. I don't know what that means, though. They're not going to put unfavorable information in there. But what I'm saying is they put in what the law enforcement said. They're saying law enforcement said that there is nothing electronically tying him to the crime in their deposition. So it's not what the defense team is saying. It's what the defense team is saying that the investigators said in their depositions. But since we don't actually have the depositions, we don't know all the things that were said. They didn't find jack shit on the search. They've got absolutely nothing. No DNA, no electronic evidence, no credible eyewitness testimony, and the unspent round is BS. Somebody had mentioned somewhere where I was hanging out that they actually know of a case in Indiana that the person was convicted with an unspent round. They never sent it to me, though. Maybe it was actually on my own live that somebody said that. Hi, Apophis. There is other exculpatory evidence not disclosed yet. Defense doesn't have to reveal until trial. State had a deadline. Yep. That's very true. The state had a deadline. They would give them a deadline too. I mean, because I think in turn, the prosecutors are going to say, hey, whatever they have, we need to have also. We're not going to, there's also a discovery deadline for the defense, but I don't think that was actually put into that motion, but I haven't read it for a little while to see if it's there. It would typically be you know, a few weeks, maybe a couple weeks before, depending on how the severity of that information is and whatever the judge ruled. Ruckus was ruckus? Frank, what time is it there? Maybe you need a nap or something. Ruckus was ruckus. Good job. That is the art of deduction. Hold on, babe. Hold on. Oh no, what did you do? Hold on, tiny human alert. He got an owie on his leg and it stings. So, yep, tiny human alert. Art of deduction. Sorry, I was giving you a hard time. Ruckus Rock said that about the unspent bullet. Maybe it wasn't his live. I haven't spent so much time in Delphi lately. I'm like, I don't even know what I'm doing. What day is it even? Even the bullet was found weeks later, but they misled by wording it in the PCA as if it was found on the day of discovering the girls. So this is like a point of contention for me because supposedly in this, you know, discovery thumb drive map, it says that it was found and logged on the 15th of February. I struggle with this. I struggle because there's no mention of a bullet in Ron Logan's search warrant. Like, that makes no sense to me. Yeah, that's true. She did. It got extended. They got a lot of time now. Hi, Southern Sweet Tea. Good to see you. Her lack of taking accountability is kind of alarming. Yeah, no, it's not. Nothing's her fault. It's not her fault. I don't know what you mean by 12, though, art of deduction. I don't know. What is there, 12 photos, 12 videos? We still don't know that, Donnie. Don't know. We don't know when it was found. We don't know how it was found. We don't know who found it. It's all speculation at this point. Do you know what case it is, though, JD Coop? I wanted to look it up, and I don't know what it is. Right. If there was additional evidence at the time, images. Okay. I struggle with that. I struggle with the images part. Unless there's images taken after. That's the only thing. Because let's walk this out for just a second. If you have 43 seconds of video, right? Hi, True Crime Web. Oh, Turner versus State. Thank you. Hold on, I'm writing it down. (2011) Indiana Supreme Court. All right, I'm gonna look that up tonight and see what additional evidence there was too. Okay, so I want to walk out this video for just a second. If you have 43 seconds of video, they tell us that the guys down the hill is towards the end of the video, right? If it's towards the end of the video, that means he's telling them to go down the hill. Now, he's either telling them to go down the initial hill, which is right off of the south end of the bridge, or the next tiny hill, down the hill, right? Guys, down the hill. If that's at the end of the video, so we know that, you have to go backwards. So let's walk it back to where Libby would have been standing at the end of the bridge, and she takes the video of him. And then probably puts the phone in her pocket. is my assumption, and why they don't actually have a more clearer image of him, because as he gets closer, she's worried he's going to see the phone, so she tucks it into her pocket. But you have to back that. So what? How long is that? Right? So it takes 20 seconds, 25 seconds to get from where he is to the end of the bridge where he's able to say down the hill, right? Now, you still have another 20 seconds, 23 seconds. That has to be the rest of the time that he's on the bridge. So I'm not sure what other pictures there could be unless there are pictures they were taking while they were walking down the trail that captured something. And 12 is a lot. And I also want to be really clear, because the images that we know of Abby on the bridge and the picture that Libby took of the bridge facing forward, facing south when they were walking, the law enforcement never released those pictures to us. They never released those pictures to us. So what if those other images were there and they were posted, they would have been released too. And why did the video stop recording? That's a great question. I don't know. Could be 18 seconds before and 2 seconds after. Right. And it could be a very little bit after, Ariel. You're absolutely right. But they're telling us it's at the end of that. So we know that that's the end of it, right? It has to end very close to right there. So everything else has to be backed up. From the deer cams? I thought you said it was from Libby's phone. You said they had more evidence, 12 photos on Libby's phone. Well, at first I think that one is a big thing, because they thought that they were meeting somebody there. So they were trying to figure out who was being met there. And I think that's where everybody came to the conclusion, and you hear some of the families' interviews, you know, around the 1-year anniversary, that they basically ruled that out. They've ruled out that social media had anything to do with it. But then a couple of years later, we find out about, you know, Anthony shots. So in Turner versus India, there was a shooting. So they used the firing pin marks, extractor marks, rifling marks on the bullet, and marks on the unspent rounds that were not fired. They were recovered, but they matched. Okay, hold on a second. That's a lot more than just the unspent. So they compared that to the actual casings that had been used, is what I'm understanding. And you guys know guns is not my thing. I suck at gun stuff. So I'm trying to put that together, JD Coop. Like, when it comes to guns, I have to research it. And then I'll forget it, and I'll have to research it the next time it comes up, because it's just not something that's in my brain. Right. That's exactly my point. So that's what I was saying. If anything, if they have even the other 20 seconds of video going back, he's going to be even further away. So it just doesn't. That's why maybe. That's always been a rumor that I've heard from the beginning, was that Abby had a phone too. And then I'm thinking maybe she had an iPod. You know, back at that time, like, those were still really big, like, and you could communicate on them. You could also use social media on them. And maybe that's why people think she had a phone, but I've always heard that she had a phone. And even in the very first, like, news, like, publications, they talk about, like, finding the phones. Hi, Nana. I may be confused, but didn't they say in the very beginning that they thought something happened shortly after they went down the hill? I thought they said that, and it was a piece of the video. That something happened shortly after they went down the hill, and it could be. I don't know. I don't have an answer for you, Nana, so you might be confused, or I might be confused. She does say that before. She does say that she didn't have a phone. That's why I'm like, I'm curious if she had like an iPod or something like that, and it wasn't actually a phone, but it's used for all the same purposes. And I know people have said that she used Libby's like iPad. She's obviously communicating on something, so she has some form of electronics. She creates a Facebook. She's got Instagram because that's what she's messaging Libby on. Let me see. So I don't know. I always heard she had a phone, but I'm going to go with it. She definitely has some type of device that she communicated with that could have potentially been there. That's why I'm thinking maybe an iPod, and maybe, it's just kind of semantics. So, but I don't even know if this point. I don't know. I guess I don't know if it even matters, because if she didn't do anything with it, does it matter? I don't know. Foxfire. I don't think Richard Allen had any idea that Libby recorded him that day. Otherwise, he would have never come forward. Neither would he have left the phone there. I struggle with this phone thing, Squeaky Wheel. I'm going to be really honest with you, because if he purposely posed the girls, which we know he did, whomever you think did it, why did that person leave the phone? They had to have thought that the phone had no evidence on it. That's the only reason to leave it. According to Anna, the only thing in the middle between guys and down the hill is the girls talking. And that's what was removed. But according to Chris Todd, the author of Forest for the Trees, he said that guys actually comes after down the hill. But according to Anna, it doesn't. It's guys. The girls say something that is removed, and then down the hill. So it is, no matter which way you look at it, what we were given is spliced. There's no doubt about it. He doesn't say guys down the hill in a fluid tone. It doesn't go that route. Hold on 1 second, guys. All right, sorry guys. He wants to watch the football game on his iPad, but I don't think it's even started yet. So, mom duties. I apologize. Or he didn't want to be tracked by taking the phone. Very possible too. And if he didn't know that it was even out, if he actually never ever saw it, then he probably thought there was nothing even important on it that had anything to do with him. Now the dog sneezed. Bless you. Tomahawk, I appreciate that. Thank you. I don't have a side. I'm not a part of any camps. Orphone was part of the cover-up. This month's of planning, and there's a lot of people who that's the theory of it. No organized killer would leave a cell phone. Well, this guy is so organized that he doesn't leave DNA and he doesn't leave fingerprints. He stages the girls and creates a scene that looks like potential sacrificial ritual stuff, but he leaves the phone. I mean, he could have tossed the phone in the water. If the consensus is that he tossed the clothes in the water, he could have tossed the phone in the water. I know. See, that's like unanswered questions that I have that I don't know if we'll even get the answer to at this point. Hold on, sorry guys. Sorry. He's supposed to do his homework before he's allowed to watch the football game, and apparently that's an issue. Hi, Ruckus. Good to see you. Hi, Johnny. Yes, why toss clothes and a shoe, but then leave the other shoe and a phone under Abby? The phone was meant to be found. The only thing I was thinking was that it was possibly in the jeans, and when she was moved to where she was, it fell out of the jeans. But then I was like, okay, well, what about the shoe then? Like, that doesn't add up. I have so many questions about some of that stuff, and then I'm almost like in my own theory, because like once again, I do all these things because I'm trying to just come up with like how I could perceive that things would have gone down. Where obviously we won't have all the information until trial. And here's the thing. People think we'll get all the information. We won't even get all the information. If you guys ever listen to like the Stout case and then listen to all the information that's come out during the FOIA requests after the Stout case was over, there's so much in there that never made it to trial. So, I mean, we'll have what information we're allowed to have at the time. But I'm thinking, in my theory, I'm thinking that there's a possibility that the girls were made to undress before they crossed the river. And that they were carrying the clothes across, and what fell was actually from the girls and not from a killer throwing anything in there. But I don't know. An insult to Stack, leave evidence like that. Maybe he borrowed her phone, gave it back. Maybe probably attempted to plant false evidence. Yeah, it's very confusing. That's tough because we may not get a solid story on how it all went down, because there may be things that they don't even know that would have happened. And until somebody actually sits down and confesses and tells the whole story, and then you have to just believe what they say, which is already tough. Okay, so we've already been on here a long time, and I wanted to make it through this last part. So let's read through this, and I'll try to make it as quick as possible, but I haven't read it yet, so I can't even summarize it for you. But this is her response to the first writ of mandamus. So this is filed on behalf of her from her attorneys. So the respondent, the Honorable Francis C. Gull, special judge, by counsel and pursuant to Rule 3F of the Indiana Rules of Procedure for Original Actions, files her brief in opposition to the relator Richard Allen's verified petition for writ of mandamus and prohibition. So the relator fails to satisfy either the conditions precedent or the mandatory requirements to even seek a writ. Nor does the relator's petition warrant relief of the merits. Relator asked this court to order respondent to unseal or to make available in the chronological case summary certain documents in this case. The court should deny the writ. Okay, good job. The court should just deny it forthwith. I need a gavel, damn it. First, by his own admission, relator has not filed a written motion seeking relief from respondent. Original Actions Rules 2 and 3A. This failure alone warrants this court to reject the petition. Second, for almost all the documents at issue here, relator has not acted expeditiously. Original actions, Rule 3A2, relator complains largely about events that occurred months ago. Third, relator has not attempted to demonstrate that denial of the petition will result in extreme hardship to himself. Relator has complete access to all documents filed in this case, sealed or unsealed. That's not true. And relator has not demonstrated extreme hardship to anyone else. It's also not true, but okay. Fourth, relator's remedies available on appeal are wholly adequate. Original actions, Rule 3A. Disputes about public access to court records are governed by normal rules of procedure, evidence, and appeal, all of which are available to a relator. Indiana rule on access to court documents. For these reasons, the petition fails procedurally. On the merits, relator's petition also fails. Most of the relief relator seeks is now moot. I knew they were going to go there. Relator has directed the clerk to enter on the CCS and make publicly available all non-confidential documents that relator requested to be made public. Moreover, respondent is under no duty to maintain the CCS. That is the clerk's responsibility. What a load of shit. She really is just throwing this poor clerk out there, man. Nor does relator identify an absolute duty respondent violated. Relator is wrong when he suggests that the parties agreed that documents would be sealed without valid grounds to do so. Nothing of the sort happened here. Finally, it bears emphasis that this court has never issued a writ granting the type of relief relator seeks here. Writs are reserved to provide extraordinary relief, not to manage the CCS. Now, I don't think that's simply it, but okay. And I find it funny that she's saying that that's the clerk's responsibility when part of the original writ was because she had documents removed that she wasn't allowed to. And we have the order where she tells the clerk of the court to remove them, which she cannot do. But now she must know that she can't do it, because if she thought she was right in doing it and she was just going to go on here and put the orders or all the documents that the relator was asking for, she wouldn't have put those back on there. So she knows that she was wrong. But they're just going to now say that, yeah, none of this actually matters because she already did everything that was asked of her. But this is obviously, I mean, it's 20 pages, so they've been writing it for a little while. But we have the brief of amici curiae that was put in this morning that also shows, so it goes against what he's saying here. Where was it? It's not demonstrated extreme hardship to anyone else. Well, they have now because they put this in today. They didn't, but the media coalition did. So they're showing like, hey, it doesn't not just affect us, the relator, it affects everybody. Oh, shit, where did I go? Make the public, respondent is under no duty to maintain. That's the clerk's responsibility. But she orders the clerk on what to do. Nor does the relator identify an absolute duty respondent violated. Relator is wrong when he suggests that the parties agreed. Okay, I already read that. Writs are reserved to provide extraordinary relief, not to manage the CCS. Well, I think there's also a few things that are put in there about her actions and the why she's taking those actions. Hold on, Kay had an excellent question. Let me go back and find it. How could they find an unspent round in between the bodies when the bodies were no longer there when the alleged round was retrieved? Well, here's the other thing too, is many people keep telling or saying like openly, and this is not, has nothing to do with what I'm reading, so we're going total side, down a little side path here, that they were processing that scene for like 4 days. But if you go look at Ron Logan's interviews, they're not there. They're not there processing that scene anymore. So then somebody said, well, maybe they're on the other side and we just don't see them in the video. Well, I'm like, okay, that's possible. But there's nobody there. There's nobody there guarding the crime scene. I mean, shit, take a look at the Idaho house. That place is still under security. You know what I mean? Like, there was nobody there. There was no law enforcement on that side to prevent anybody from walking in there. Anybody could have walked in there on the day that Ron Logan did that first interview, which I'm almost positive was the 15th, the day after they were found. So, I'm in agreement. Thank you, Tornado Artist. I appreciate it. Okay, so the Supreme Court has the power by writ of mandate and prohibition to confine a lower court within its lawful jurisdiction. Okay, writs of mandamus and prohibition are extraordinary remedies which are viewed with disfavor and may not be used as substitutes for appeals. Original actions rule. Okay, this court will not issue a writ unless the relator has a clear and unquestioned right to belief, and only where the court trial has an absolute duty to act or refrain from acting. Okay, so here's the argument. The relator does not meet the conditions, precedent, or mandatory requirements to seek a writ. The relator has failed to satisfy the conditions, precedent, or mandatory requirements for filing an original action. Based on its procedural deficiencies, the petition should be denied. Relator admits that he failed to comply with conditions, precedent for original actions to seek relief from the trial court. Original actions require a relator, before filing his petition, to first raise the issues presented here to the trial court in a written motion. Relator admits he did not do so. He did not file a motion with the trial court seeking to unseal or make public any of the documents identified in his petition. The court should not entertain relator's petition for this reason alone. That's also not true in its entirety. They did request for the hearing on the 19th to be unsealed, and they requested the transcripts from it, and they were denied. So they had to take that up with the Supreme Court. Is that and how are you going to go in front of the court and be like, hey, you removed all of these, saying that you don't want them there because these aren't even the attorneys of record. You made the decision to remove them, but we want them back. And the judge is going to go, oh, okay, well, since you want them back, I guess we'll go ahead and do that. Now, I understand that probably what they're saying is when it comes to like those 118 whatever that were in the zip file, that nobody went in and requested that they actually be put back into the case summary, maybe. So that's kind of, in my opinion, kind of true, kind of not true. It's all encompassing when it shouldn't be. The relator requests that he be excused from this condition precedent due to extraordinary circumstances and a practical impossibility. Well, yeah, neither is an exception under Rule 2A. Okay. And relator cites no authority to support such an exception in original actions. Rather, relator suggests that the Indiana rules of appellate procedure allow for excuse of analogous condition precedent under extraordinary circumstances. Blah, blah, blah. Condition precedent under extraordinary circumstances. Appellate procedure allow for condition precedent under extraordinary circumstances. The rules of appellate procedure do not apply to original actions, which are governed exclusively by their own rules. Original actions Rule 1. Moreover, relators claim that there is an impossibility of performance of the condition precedent is wrong. Relator asserts that the trial court refuses to accept any filings made by attorneys Rosie and Baldwin and orders the clerk to remove anything they file. Relator's brief in support of petition for writs mandamus prohibition, but the trial court has not prohibited relator from filing motions with the trial court via his current counsel or himself. That doesn't matter. The whole thing was on behalf of them. Relator has highly competent counsel, including the attorneys who filed the petition. In addition, the trial court has appointed new counsel for relator in the trial court case, as relator acknowledges. Nothing prohibits any of these lawyers from entering appearances with the trial court, including limited appearances on the issues presented in his petition. For the narrow purpose of first requesting relief from respondents, relator cannot claim impossibility because he directed his current counsel to file a premature and incomplete original action. Ooh. But there's still attorneys that can file. So once again, it's not all encompassing. They like it. They would like it to be, but it's not. Finally, as discussed further in the next section, relator seeks relief arising from the respondent's actions as early as June 2023, including a trial court order dated June 28, 23. Petition at pages 9 and 10 between June 28th and October 27th. Relator claims that he does not accept this appointment and he has not authorized these new attorneys to act on his behalf in any manner. This is irrelevant because he is not prohibited from filing a written motion with the trial court regardless of whether he accepts court-appointed counsel. In fact, one of the relator attorneys has done just that. On November 2nd, 2023, relator's attorney, Kara Winicki, filed a limited appearance for the purpose of requesting transcripts, in which she advised the trial court that her appearance is limited for the purpose of requesting transcripts necessary for the original action. Ms. Winicki entered this appearance in connection with another original action relator filed. Well, isn't that interesting? Because he's now saying that they didn't go to the judge and ask for anything. And here he's saying, oh yeah, she did file an appearance and limited for the purpose of requesting that. But it still doesn't change that she took the other attorney's stuff down. He's like, wait, the relator, you didn't get your stuff taken down, so you can't really complain. She left your stuff there. Doesn't matter if she took the other stuff down. It's not your business. Like, mind your business. I don't know all these rules, and I definitely don't. I mean, even what I do know about law, I'm not good with appellate stuff. That's not where I ever... Civil and appellate was not what I ever was studying. You know, just the mini scope of it. Okay. Yes. Thank you. Okay. That's not the score, baby. Okay. Ravens have 7. Bengals have 0. Good job.
No. 0 is nothing.
Yes, that's 0.
7 nothing.
7 to nothing. Okay. Thank you, babe. Okay, where was I at? Response actions is as June 2023, including a trial court order dated June 28, 2023 through October 7th. Okay, so when relator received notice that the trial court had stricken filings from Rosie, relator had ample opportunity to file written motions with the trial court challenging the court's decisions, but relator never did. Relator's compliance with Rule 2A was not an impossibility, factually, legally, or practically. The court should deny the petition for this reason alone. Okay, this is what I'm not familiar with, so I don't... We'll have to look that up. Relator failed to file his petition expeditiously. Original actions of mandate and prohibition must be expeditiously filed. A lot of citations. Although no specific statutory provision prescribes the time for judicial review, such action must be brought expeditiously and without unnecessary delay. Okay. For example, this court has found that the delay of 42 days was too long to seek a writ with this court. Okay. Relator baldly asserts that the application has been made expeditiously, but relator seeks relief from actions that occurred on the following dates. Okay, so they're saying because it took so long for them to file this, they're not... Oh my gosh, Kay, that's too much. Thank you. I appreciate that. That's too much. You don't have to do that. I appreciate that. Thank you. Okay, so they're saying it's not expeditiously because what they're asking for was actually back in June and July and September, and so if they had such an issue with it, they could have gone and asked at that time for any of those things, and they didn't. October 25th, 26th, 2023, Allen's verified notice of continuing representation motion to disqualify. Okay, I mean, I got to give him that. I mean, that's a fair point. It's not expeditious when they're complaining about things that happened months ago, right? Relator filed his petition on October 30th, 2023. That was 42 days after Relator filed the September 18th memorandum, the exact same delay that the Supreme Court found to be excessive in 19th hole. The delays from the July 5th letter, 117 days, June 28th order, and the June 20 filings, 132 days, are even longer. Relator has offered no justification for these delays in filing an original action. Relator's petition is expeditious only to the extent that it seeks to reinstate the October 26, 2023 filings. However, Relator's request for this minor relief cannot save his otherwise untimely petition. This court should not issue an extraordinary writ on matters that the trial court decided months ago and that the relator never challenged before the trial court itself. Relator fails to show that the denial of the petition will result in extreme hardship. All petitions shall state facts showing clearly that the denial of the petition will result in extreme hardship. Writs of mandamus and prohibition will not be used unless the relator can show a clear and obvious emergency where the failure of the Supreme Court to act will result in substantial injustice. It is not the policy of the Supreme Court to issue these extraordinary writs against lower courts on slight occasions, but only in special cases to prevent impending injury. This 19th hole Inc. case they like that case. Relator's petition claims, as explained below and in the accompanying brief, the denial of this application will result in extreme hardship. Yet, Relator never states any facts in either the petition or the brief, showing clearly that he would suffer extreme hardship. The petition is insufficient under original actions rule. Instead, Relator argues that restricting access to the court records at issue generally harms the public, but stops well short of arguing that it causes the public extreme hardship. More importantly, Relator never alleges that he would suffer extreme hardship. If the documents at issue remain publicly inaccessible, I can't argue with that. I'm in agreement here, nor can he. As a party, Relator has complete access to any court documents, regardless of whether they are public or confidential. That documents are under seal does not hinder in any way Relator's defense of the criminal charges against him. Although Relator raises arguments about his Sixth Amendment right to counsel, these claims of harm have nothing to do with the relief he seeks in the petition. Well, I think it would also be really interesting if any of this was brought up by those defendants, or not by those defendants, by those defense attorneys. If they brought up any of these issues on what she was doing wrong, say it's behind closed doors for whatever reason, if they brought it up, then I think they have a leg to stand on. Relator fails to show that the remedies available by appeal will be wholly inadequate. All petitions shall state facts showing clearly that the remedy by appeal will be wholly inadequate. If a court decides erroneously, the remedy is through an appeal. Far too frequently, writs of prohibition and mandate are sought to be used as a shortcut to an appeal of the merits, which cannot be done. Relator's petition asserts that his remedy available by appeal will be inadequate. But Relator again fails to demonstrate why appellate remedies would be inadequate, wholly or otherwise. The Indiana Access to Court Record Rule specifically contemplate parties must use the ordinary appeals process to resolve disputes arising under this rule, Access to Court Records Rule. For that reason, the court and the Indiana Court of Appeals regularly entertain appeals regarding access to court records. Whether trial court properly complied with Administrative Rule 9 and ordered certain court records excluded from public access. Citations. Indeed, Indiana's appellate courts regularly decide the type of issues regarding access to court records that the petition raises. Fair enough, but she's like a placeholder is what we're looking for. Application of Administrative Rule 9, predecessor to the Access to Court Records rules, to trial court's order limiting the use of court record and barring its broadcast or dissemination, an appeal by intervener media entity. They're just citing a whole bunch of stuff right now. An interlocutory appeal of trial court's denial to seal case. This is actually what I thought that there would be the next. This is what I thought would be the next step, is this interlocutory appeal. But I don't know. Of trial court's denial to seal case record. Whether the trial court erred under Administrative Rule 9 by excluding from the public record portions of a party's deposition testimony. This is a whole bunch of citations. Whether the trial court erred by concluding that certain materials obtained by the appellate during discovery and file in court should remain confidential. This is all just essentially saying that she has the right to make things confidential, which I don't think is the question. I think that the problem is that she's not putting anything there. She's not putting anything there to say that any of this stuff was even filed. I don't think it's the issue that she has the right to mark things confidential, but they're citing a whole bunch of stuff that shows that she has that right. But I don't know if that's part of the question. I think she just has to cite her legal rule on why. Okay, so Indiana rules of appellate procedure reinforce that the relator may request the relief he seeks from the trial court, and if the trial court disagrees, seek a remedy through the normal appellate process. Okay, so that Richard Allen, through his attorneys, can request the court to put all the things onto the CCS, and if she denies doing it, then they can go appeal that. That what they're asking for in this writ is not necessarily, does not need to be a writ of mandamus. If any disagreement arises as to whether the clerk's record or transcript accurately discloses what occurred in the trial court or the administrative agency, any part may move the trial court or the administrative agency to resolve the disagreement. The trial court retains jurisdiction to correct or modify the clerk's record or transcript at any time before the appellate reply brief is due to be filed. After that time, the movant must request leave of the court on appeal to correctly or modify the clerk's record or transcript. The trial court or administrative agency shall issue an order which shall become part of the clerk's record that either confirms that the clerk's record or transcript reflects what actually occurred, or two, corrects the clerk's record or transcript including the chronological case summary of, if necessary, to reflect what actually occurred. Okay, so that's what she's doing. So they're saying that she can do this, and so that's what she's now doing. Her motion or her order to have her court clerk put everything back on the record, that's what she's doing. So she has the right to do that. And look at, she can control that, but the clerk of the court is the one who's actually in charge of it. The relator believes the CCS is inaccurate or incomplete, or that documents should not be sealed. Rule 32 of the Indiana Rules of Appellate Procedure provides still another avenue for addressing any such concerns. Same thing. Goes in front of her, says, hey, we want these put back on here. She says no. They go file an appeal. Due to the petition's multiple procedural defects, the court should decline the issue a writ and need not consider the petition's merits. The petition fails on the merits. Okay, so that was the legal side of it. Let's see what it is. Let's see what this is. Even if a relator had satisfied the conditions precedent and mandatory procedural requirements for an original action, which he has not, the petition fails on the merits. At the outset, most of the relief relator seeks is now moot, because she went and ordered her to put it all back on there and blamed her for it because she was busy making a website. We got you. Respondent has issued an order directing the clerk to make available to the public on the CCS all non-confidential documents relator request to be made public. In any event, respondent has no absolute duty to maintain the CCS. That is the clerk's responsibility, not respondent's, nor does respondent have an absolute duty to reinstate documents filed by attorneys after they no longer represented relator. Respondent also has no absolute duty to provide the public with remote access to records, much less the particular form of remote access that relator requests. This court should deny the petition. Most of the relief relator seeks is moot. On November 14, 2023, the trial court issued an order that resolves most of the public access issues raised in the petition. First, respondent has ordered the Carroll Circuit Court clerk to put the 118 documents previously made remotely accessible by court order on June 18th to put them on the CCS. Second, respondent has ordered the clerk to unseal the June 20th, 2023 filing by the Carroll County Sheriff and the July 5th, 2023 letter from a DOC inmate and place them on the CCS. Third, respondent has ordered the clerk to place and make accessible on the CCS the October 25th, 2023 filings by Rosie to the CCS. These filings remain stricken from the record and will not be considered because they were filed by an attorney who was not an attorney of record for a relator on the date of the filing. This is gonna be the big thing. I'm going to put my money on it. They're going to have to argue the fact that he never withdrew. He didn't withdraw. So he verbally withdrew, but it's just like, so somebody confesses because the cops are beating the shit out of him. It's coerced. This is why those transcripts are going to be very important. And without knowing what was actually happening in there, it's that they're going to have that. Because if he walked out and was just like, fine, whatever, and if he actually walked in there and said, no, I think that you're really, you're pushing the envelope here and trying to get me to walk out when I don't want to. Yeah, Rosie never withdrew. Even in her own words, she says that. But then other people are like, well, nope, he quit. And that's just like saying the guy who's getting the shit beat out of him, he's the one who he confesses to the crime, so he must be guilty. So if he filed those and he was he was still the attorney on record, then they should still be there. But she's just determining that that's not true, that she had a finding of gross negligence. It's all going to come back to that. These filings remain stricken from the record and will not be considered because they were filed by an attorney who was not an attorney of record for a relator on the date of the filing. Show me where he withdrew. She puts in there that he withdrew. He does not ever submit anything withdrawing. The trial court's November 14th, 2023 order renders most of the issues in the petition relating to these documents moot. The clerk, not the respondent, is required to maintain the CCS. Then here's the thing. If you guys really blame the clerk, then she should be fired, right? Let's see if this clerk gets fired for not doing her job. You think she'll be fired? Because I don't. She's a scapegoat. But I mean, if she really screwed up this bad that now that the judge has to actually go and put an order in for her to do her job forthwith, she shouldn't have a job. She's a terrible court clerk. She won't be fired because she's like, but you got my point, Ariel. The clerk of the circuit court shall also maintain the following records as specified under this rule. Chronological case summary, the case file. The clerk of the circuit court shall maintain a sequential record of the judicial events in such proceeding. Okay, so let's just break this down real quick. So clerk of the court screws up and puts all these 118 filings in this zip file and sends them out, but doesn't put them on the CCS. Totally clerk of the court's fault, right? She's terrible. Now, the next big thing that they're talking about is the Franks memorandum. Who took the Franks memorandum down and why? So that's a big one for me right there. So even if we go with, okay, clerk of the court totally screwed that up. And now Judge Gull over here on the October 25th, 26 rulings is, we're going to play devil's advocate and we're going to say she's right. I have to cough. Hold on. We're going to say she's right and that Rosie withdrew and he's no longer, he's no longer part of the case. So take his stuff and get rid of it. Where's the Franks memorandum? Gull ordered it taken down. Man, she's just got so many reasons for all of her shenanigans. Most of it not her fault. She's such a good judge. The clerk of the circuit court shall we already read that. Indeed, relator concedes that the trial court clerk is to maintain the trial court case records. Verified petition. Similarly, relator repeatedly refers to the person who allegedly violated the duty to provide public access to certain records as quote-unquote someone. Someone within the court system, sua sponte, changed all of Allen's filings to confidential. Someone within the court has since excluded the Franks memorandum from the CCS altogether. Relator's allegations against someone are no basis for a writ against the respondent. You can't prove she did it, so you can't say someone. Respondent did not abuse her discretion in managing the docket, much less violate an absolute duty. The trial court has broad discretion in managing its docket, declining to second-guess the trial court for allowing one motion to be filed but not another. Respondent has no absolute duty to manage its docket in the manner sought by the relator. Nor does the respondent have an absolute duty to provide a particular type of remote access. Indiana law does not require court records to be remotely accessible. Is that the law that there's a law that's changing in Indiana on January 1st? I think that's it. I think that court is changing it where it has to be accessible. I'm gonna have to look into that, or some one of you guys knows, let me know. While this section encourages courts to make the designated information available to the public through remote access, this is not required, even if the information already exists in an electronic format. Respondent has ensured that the 118 documents on the zip drive have been and remain publicly available online since June 28, 2023. The June 20 and July 5th documents appear on the CCS record, even if they are not accessible online via the CCS. This does not mean they have been otherwise excluded from public access. A court record may be publicly available even if the public is unable to download it from the CCS. A court record is excluded from public access only if the record is not available for public access in the courthouse during regular business hours established by the court. In any event, this request is moot because of all the reasons we already said. Good job. Relator further asserts that respondent wrongly allowed the parties to agree to exclude certain records from the court's CCS. Nothing like that happened. In the trial court's June 28, 2023 order, respondent explained that the court had an undisputed legal basis for sealing certain records, including the unredacted affidavit for probable cause. Hold on. Respondent explained that the court had an undisputed legal basis for sealing certain records, including the unredacted affidavit for probable cause, listing names of juvenile witnesses. The transport orders for security purposes and defense ex parte motions and related orders pursuant to long-established case law. The parties did not agree among themselves to exclude these records without valid legal grounds, nor did the respondent rely on Trial Rule 26 protective order to justify the exclusion. The respondent harmlessly noted that the parties agreed with the court's stated legal basis for sealing the records. Okay? Relator also seeks to unseal or restore public access to the Franks Memorandum. All right, I'm going to check in on you guys before we hit the Franks Memorandum. The corruption has been going on for decades and protected way up the chain. The big tell is, why was the FBI called off the case so early, and who called them off? Meghan Markle would not have done it this way. She would not have. She hasn't even read the memo. I bet she still hasn't read the memo. She doesn't give two shits what's in the memo. It probably doesn't need to, because the new attorneys probably aren't even going to use it. Watch that thing be buried. Journalistic heathenry. Don't my wants surpass the rules? I have a black robe. Respectfully submitted, Laura. I was hoping Gull was going to clear up a lot of this today. I even gave her the benefit of the doubt. All of this sidestepping and blaming ain't cutting it for me. I'm moving to the fire Gull area. Ooh, squeaky wheel. It's the motion reminds you of McClellan where he claims things that are irrelevant but true. That's pretty much just how he talks. But she has been, Southern Sweet Tea, yes, she has been managing the docket. It's not her responsibility, yet she's the one who just decides everything. Yeah, someone. Just someone. You can't say it's the judge. You can just say it's someone. That freaking clerk, man. I'm telling you. Her attorneys. Yeah, sua sponte on their own. Yep. Did she close the response with, "Neener, neener, neener. You said someone and you didn't say my name"? At this point, I think they know they have the wrong guy or trying to cause a mistrial. Either he dies in there or gets released, goes cold, and they blame the public. We had the guy. Yeah, I don't even know if they care if they have the right guy. I don't know if they, I would be very curious to know if they actually believe they have the right guy. Like, are they fighting the good fight because they truly think he's the one that did it? No, she can't do that. She can't do that. The clerk probably didn't do anything right. She probably didn't record it or didn't create the transcript. It's probably the clerk's fault. Yeah, the clerk is so bad. Maybe she's the leak. So you think of hot sauce? I think of hot dogs. Like Franks and beans. Oh, goodness. I've probably been on here too long. They must have DNA criminality. And why I say that, after 6 months or so, they took DNA from all the family to check and see it didn't match they had from this scene, maybe just asking. I believe that they have DNA. I have a theory around the DNA. I have nothing substantial that backs up that theory, but it's my theory nonetheless. I believe there's something that was at the crime scene that has DNA, but they couldn't tie it to the crime itself to be the perpetrators. And the person's DNA that they found had no record. The person was not in the system. They ran it through CODIS, not there. But what they needed was to figure out how this, whatever this was that was left there, why would it have been there from this person? Was that person ever even there? That's what I think. That could change when more info comes out. So I said I have nothing to back. That's just my theory right now. On 6/15, no suppression hearing without a Franks motion. So file the Franks, and Gull says, "How dare you? How dare you? You cannot file a Franks motion like that." She pulled a Becky Hill, that sneaky little clerk. Oh, yeah, that's true. Why the hell doesn't Gull explain why she told RA that she couldn't let Baldwin and remain his lawyers? Rozzy, not to us so much, but to RA himself. Doesn't she owe him that? Well, she owed him the right for him to actually be there while she was removing his counsel and creating a quote-unquote finding that they had committed gross negligence. She cared more about McLellan's opinion on whether the defense lawyers had committed gross negligence than she cared about the actual defendant's opinion on whether they committed gross negligence against his case. It's him. The whole trial, the trial is for him. It's not for Abby and Libby necessarily. It's for him. It's to preserve his rights. It's to get justice for them in the end, but the trial is for the defendant. As weird as that sounds, that's who it's for. It's to protect his rights. Hi, Shane. ATS, remember Ron Logan had dogs. Maybe they left some hairs. The girls were only a few hundred yards from his house. I've always thought that too. And he also had horses. So did they go and like take the animal hair from every one of his horses? I've always wondered that. If he passes away now, this case is closed. I'm telling you. Yeah, we need to depose the clerk. Somebody needs to depose the clerk. She's probably just sitting over there going, "This fucking bitch. How dare she blame me when she's the one telling me I can't have this and I can't put that and da 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 da." Could you imagine the backlash from the public? The backlash from the public if they actually came out and said, "Sorry, Richard Allen, not the guy." They can't. There's no way. Because even just think of like Judge Diener, who says, the amount of bloodlust about this case. Imagine what would happen if they actually came out and said, "Sorry, we screwed up and we didn't get the right guy." Yeah, that's what I think. Sad part is they haven't even gotten to jury selection yet. I'm like, no, they're pissed because Ari's attorneys did their job poking holes in their case. They just keep going with this gross negligence thing. But I'm like, why wouldn't you just go and put that out there then? Just go and have the hearing and say, here's all the things, here's your witnesses, here's their witnesses, and let's let it be. Well, Justin, thank you. Why did judge allow inmate letter onto docket unredacted? If letter true, writer is in for a ton of hurt now. Yes. Yeah, exactly. So I was like, maybe you should have redacted this. Like, this guy's actually naming names. He's actually putting names in there of the people who have abused him. And I don't know what kind of follow-up's been done, but let's just say that they're like, oh, well, now our names are on there, you piece of shit. Whether he's actually telling the truth or not. Like, that guy's life is in danger. Even if Ari is truly innocent, it doesn't matter now, as his whole life and family life will forever be tarnished and destroyed. Yep. I'm starting to feel that way. I really am. I'm feeling like we were like this pointed in this look over here, but we're really actually looking over here. The sketches are garbage to me at this point. I still can't figure out on that thumb drive map, why the hell would they need a composite sketch from the funeral home? Was he there? And if he was there, why has nobody ever mentioned that this dude was there and what he saw? He's never Carl Abbott. We're at the funeral home, but he's listed under composite sketches. Why would he have a composite sketch? Yeah, what if he's just a guy on the bridge? That's what they essentially said at first. Remember, the guy on the bridge was just a person of interest because they had identified everybody else that was at the bridge except for him. So they just needed to talk to him. They could not say whether he was the same man who said guys down the hill. They could not prove that back then. I don't know what has changed that they now think they can. I'm not sold either way, but I know that there's a lot of people who do think it's fake. And I was actually looking at some of the stuff with the pictures and trying to dig into some Snapchat info on how all that works. Yeah, he looks nothing like the young guy sketch. Disregard the old bridge guy sketch. But then you have Carter who comes out and he's like, put them together. And remember, the sketch is not a photograph. Put them together. And there he'll be. Okay, Relator also seeks to unseal or restore public access to the Franks Memorandum. The Franks Memorandum contains the full first and last names of the deceased minor children who are the crime victims in this case. Who are the crime victims in this case. It contains their full first, last names of the deceased minor children. That Franks Memorandum said their names. Names of minor children are required to be redacted from court filings in federal courts. Okay, names of minor children are required to be redacted from court filings in federal courts. Indiana, in turn, excludes case records declared confidential or excluded from public access pursuant to federal law, access to court records. Therefore, the Franks Memorandum is marked as confidential. No, it was not marked as confidential. It was marked as removed. And she tells the clerk of the court to put it back on there and mark it confidential. Nice way to get around that because it's already done, so it makes the whole thing mute, according to them, right? The Franks Memorandum is marked confidential. Bullshit. It was not. It was removed because counsel failed to supply a redacted version at the time of the filing. But, you know, give this woman so much credit because she put 118 documents out. Remember, she put 118 documents out, you guys. Let's bring them back up so you guys can see all the documents she put out. Oh, look at all the 118 documents that she stuck into the zip drive, right? While she was building her website. Oh, look at all the names. Look at all those names not redacted. Damn. Damn. Does that say the deceased girl's actual full names? Is that what that says right there? I don't know. Probably should have been marked as confidential, not thrown into a zip drive. Therefore, the Franks memorandum is marked as confidential as of the 14th. But back in September 19th, we actually just completely removed it from the docket. We acted like it didn't even exist. And then people try to keep saying that they leaked it. So tired of hearing that document was leaked. That document was not leaked. It was posted. It was downloaded by some of us, and then it was passed around. Confidential. Because counsel failed to supply a redacted version at the time of the filing. Man, I was more concerned with the fact that they put all those other people's names out there. I was like, damn, if these guys don't have anything to do with this, this is ouch. Especially like Elvis's sisters' names. You know, like not even the people they were blaming. They were just like, yeah, we're putting everybody out there. I was more concerned with that. Respondent has ordered relators' new defense counsel to review the pleadings and either adopt them or make their own. If counsel adopts them, they are ordered to file a redacted version. We talked about this already. They are ordered. The new attorneys are ordered to file a redacted version. The old attorneys were not. They were not ordered to file a redacted version. Finally, the relator has not cited a single case where the Indiana Supreme Court has issued a writ of mandamus to grant the type of relief the relator seeks here. This court has never mandated that a trial court reinstate documents filed by attorneys who no longer represent a party, make documents available to the public on the CCS when the trial court had already made those documents publicly available, or comply with certain access to court record rules or statutes. Relator's petition does not seek the extraordinary relief reserved for an original action. Should this court grant a writ to relator, the court will become inundated with petitions alleging that trial courts across the state committed a technical violation of the access to court record rules. Disputes of the type relator raises are best resolved by the ordinary appellate process. The court should decline to grant the relief requested. Now, Judge Gull did nothing wrong. She did nothing wrong, you guys. But for whatever reason, 2 days before she had to reply to this writ of mandamus, she reversed everything she did. But she did nothing wrong. But yet she changed all of it. If I did nothing wrong, why would I not go in fighting and saying, oh, hell no. Hell no. I have the right to keep this shit sealed if I want to. And I have the right to do it this way because this law and this law and this law that you cited in here in your response tells me I can. Why would I go in there and take it and just change everything back to the way it was if I didn't do anything wrong? That makes no sense to me. Conclusion. Respondent, the Honorable Francis C. Gull, respectfully requests that this court deny the relator's verified petition for writs of mandamus and prohibition. And we verify that this has 3,752 words. So there's a few things in here I don't know. I don't know about the specific rules that they're talking about, and that's something that I'll look into, depending on if this even becomes an issue. Because to me, this one was kind of the stay, just like stop everything for a minute and just let her know that, hey, we're moving on up. The next writ of mandamus, where they're actually filing to have her removed, and they're actually filing to have the other attorneys reinstated, I think is going to be more impactful and more powerful, because she can't go and cover that up. So I feel like she's doing this and putting everything back the way it was, so she can be like, look, see, I did what they wanted, and they still, it's just, look at the bloodlust. There's bloodlust. The judge would have released the transcript if she did nothing wrong. She's a liar. That's exactly what I think. It makes no sense to me that she'd go through all of this when she could just be like, look, here it is. Oh, he has a paternity case? Oh, jeez. Oh, Bob is going to be jumping out of his chair. Yes, he is. Does he have a live scheduled? He's got to be going live to go over all of this. Some of you guys are like, I'll listen to it for the 4th time. I'll listen to it just because I love his and Allie's opinions. Right. And he's adamant. He's adamant that no, like you really pushed us out, and I want to prove it. And this is a really weird hill to die on if he's lying. Right? I agree. I think so too. 8 p.m. what? 8 p.m. what? I'm going to wrap this poll up real quick. So final tally is, will the Supreme Court remove Fran C. Gull? Yes, 71%. No, 29%. Oh, I'm on the edge of my seat. I think you guys are voting yes so that we put good fortune out into the world and then it happens. But maybe it's a be careful what you wish for. I don't know. All right, we'll end that. Let me go see. Let me see when he's going live. Okay, so he's going live in a little less than an hour, it looks like. So yeah, about 53 minutes from now, Defense Diaries. I don't know if I'm over there right now. Let me just grab the link in case if you guys aren't. I think everybody here is subscribed over there, but just in case you're not. It's one of the most lively law discussions you'll ever have, I promise. If I can share a link with you. That should work. All right, let's see what you guys have to say before we go. Oh, you got it too? Okay, perfect. Yeah, Bob's channel. Wait, Cletus has a love child with some stripper from... What? Oh my gosh, I don't know. I don't even know if I want to know. You kept typing BH, didn't know who that was. But you typed his actual name. I remembered hearing things on here about him. If you knew who I really was, you'd be so embarrassed right now. Hi, Mel Mac. Hell yeah! Do they ever name Abby and Libby, or do they always just say the girls on the bridge? No, they always name Abby and Libby. Not only do they name Abby and Libby, who are deceased, they name all of the witnesses that are not. All of the juvenile witnesses that they wanted to protect and were redacted from the PCA. In all the other documents, they put their names straight out there. The rules are for thee and not for me. I would love, but doesn't she have government immunity? No, the Supreme Court can actually make decisions that overrule her. She does have a lot of power, though, and that is scary. Oh, gosh. No, not here. I do not. You want Watts coverage? ATS News. My lovely friend right here, ATS News. She is my Watts go-to and probably the only person that can even get me to listen to anything Watts anymore. I hate that case. It gives me the heebie-jeebies. Just brings back so many bad memories. Hi, Julio Suave. Back in the 90s, Nick's house burnt down here in Logan. It wasn't a nice house, but they moved up like the Jeffersons real quick. Ooh. Well, isn't that kind of interesting? Did his dad burn that house down? Yeah, this is Delphi. She has immunity from being sued. Yeah. Yeah, he was a pyro, but I don't remember what he actually burned down. And I don't want to speak ill of the dead. I don't even know if we're allowed to say his name, right? Because it should be redacted. But no, he's not. He's not a minor. Yeah, Indiana's got a lot of fires. It's quite weird. We have a lot of fires out here, but mostly because of like wildfires. Not because people are just going around setting shit on fire. I don't know what's up with the pyros and the arson in Indiana, in the Midwest in general, but Indiana seems to be a lot. Delana, Chris Watts is in jail rotting. That's my update. He burned his work down. Aww. I need to wrap this up because I want to look more into the Flora stuff. I know the general gist of Flora, but I've never dug into like the details or the court documents or anything like that. I just know the general gist of the story. I'd love to look at that though. It's another 4 little girls that just no justice. It all starts with meth. That might be a big thing too. That's true. And meth is really big in the Midwest. No way, Tomahawk. Are you serious? The ISP's canine is Odin? Oh, shit. Fire helps hide a lot of evidence. Not all, but a lot. It's true. Hey, AJ. I know. It's just I can't even imagine. All right, I'm going to wrap it up with you guys. I appreciate you guys being here. I appreciate you guys hanging out and just listening to me read through this craziness of the court clerk is a terrible human being and shouldn't be elected, should be fired. I will be hanging out in Bob's chat probably later, which is in about almost 45 or a little over 45 minutes. Hold on, what did Tomahawk say? I missed it. Where is it? Tornado artist. Now you guys are the best. I like hanging out with you guys. I missed you the last couple days. But I needed some rest. I needed to like decompress and like just you start going down the rabbit hole of all the connections and stuff, and it's like yeah. Any Watts people want answers? Go check out ATS News and the documentary over there. It's amazing. I think she hit 1 million views on that thing because it's so freaking good. But I don't touch Watts with a 10-foot pole. Anybody wants my notes from that case? I will. They're like bad juju to me, so you can have them. I should be back tomorrow. I have a couple more things. I have a couple things planned, but I should be back tomorrow. Don't hold me to it if I don't make it, but I should be. But either way, I will see you guys around the YouTube streets regardless. I appreciate each and every single one of you guys for coming here and hanging out and just being kind and listening to all the crazy Delphi stuff. I don't even know what we're doing anymore, but we're doing it. All right, I'll talk to you guys later. Have a good one.